I'm going to.
I love getting.
Okay.
All right.
Page 4, we have 1 through 4. Okay, what else?
Yeah. And then page 5, 1 and 14. That's you guys stop.
Okay, that's fine.
Okay.
That's it, okay?
Yep.
Awesome.
Okay.
And with no objections in this. Okay.
All right, the 21st is now in session. The Honorable Judge Nathan Miller sitting by assignment. I already lost it. Yeah, one more, River. Maybe. You're fine.
Good afternoon, everybody. Please be seated.
Good afternoon.
We have any quick to deal with this afternoon?
Yes, Your Honor.
Let's hear it.
Of course, just by way of introducing ourselves, my name is Kusha Jamali, alongside co-counsel Timothy Williams, and we represent the plaintiff, Ms. Madeline Thornberry, individually and in her representative capacity of her husband's estate.
Okay.
Our housekeeping matters are, we've had a very productive pre-trial meeting with the opposing counsel. We have agreed to admit a certain number of exhibits. Would you like to hear them?
Sure.
Exhibits 2, 3, 5, 6, 10, 11, and 14. May we assume that all witnesses have been pre-sworn?
You may.
May we move about the well freely during examinations and opening and closings?
You may.
May the jury instructions be constructively read to the jury prior to closing arguments?
Yes.
May we have a brief recess after the plaintiff's case in chief?
You may.
And what is your preference on Henry experts? We have an expert in service.
If they're coming in by agreement, y'all can ask them to come up to the bench anytime.
Thank you, Your Honor. And finally, as you're aware, Mrs. Madeline Thornberry, the plaintiff in this case, has COVID and she will not be able to join us in person. We have deposition designations. We've agreed with them with opposing counsel. There's only one line or 3 lines that are objected to now. Would you like to take those objections when we are going to call her or now?
We will take them up when we call.
Sure thing. And with that, Your Honor, the plaintiff is ready to proceed pursuant to 2 motions in them.
All right. Sounds good. How about the defendant?
Yes, Your Honor. My name is Aidan Lathrop, and I, alongside with my co-counsel, Jacob Resendez, we represent the defendant, Thomas Thompson. We have a few housekeeping matters ourselves that Mr. Resendez will read out to you.
First, Your Honor, one of our team members today had a personal emergency, so both of our witnesses will be played by the same individual. We just wanted to make Your Honor aware of this in case of any confusions when calling both of our witnesses.
I appreciate that.
Next, Your Honor, we would like to ask to constructively invoke the Rule 615, just so that any objections are heard outside of any witnesses that are not experts.
The rule is constructively. I'm sure, right?
Thank you, Your Honor. And then lastly, we would, defense would also request a brief recess after our case in chief.
Sounds fair. The plaintiff gets them.
Thank you, Your Honor.
What was that last housekeeping matter again?
A recess after the defendant's position.
Your Honor, we have a courtesy copy as well for you. Would you like it?
You may approach.
For plaintiff team, what are y'all's initials?
Kusha Jamali KJ,
Okay,
and my teammate is TW.
thank you.
Of course.
What are y'all's
Defense, Jacob Resendez, JR. Avon Lathrop is AL.
Thank you.
Anything further from the defense?
Just 2 motions in the lead.
Let's start with the plaintiff's motion.
Yes, Your Honor. By way of background, as you're already aware, this is a case about the defendant, T-Bone Thompson, accepting government funds to place runway lights on his property. These runway lights are supposed to make it safer for pilots to be able to land on. And the only requirement that the government has is if they stop working, you either fix them or you notify the FAA. The defendant didn't do any of those things. Because he didn't do that, Mr. Zeke Thornberry died. And he didn't just pass away, he suffered for 5 to 7 minutes with a copious amount of injuries. And that's agreed to by both parties. And because of that, Your Honor, we have a motion limiting in 2 parts. One of those things is that there's an NTSB report, the National Transportation Safety Board. This came out with their own investigation. In that report, this agency has come out and determined a series of probable causes. Because this word probable cause is so similar to proximate cause that the jury will be able to find at the end of this case, we argue that this under 403 confuses the issues for the jury because if you were to flip to exhibit number 1, the last page, this NTSB report specifically says that Mr. Thornberry, the pilot in this case, he was a proximate cause, he was a probable cause to his own death. We anticipate the defense to put this exhibit up, show it to the jury and say, hey, just because the NTSB found Mr. Thornberry to be a probable cause of his own death, you two members of the jury, you should agree with them and you should find just like they did. Because of this reason, we would like to either exclude the entirety of this exhibit or just redacting probable cause section 2.2 and 2.1 of this exhibit.
Response?
Yes, Your Honor. The probative value of this exhibit and explicitly the list of probable cause outweighs the prejudicial effect because the jury should have a right to know that the national agency who is in charge with finding out the causes involving aircraft accidents, the jury should be able to hear what that agency who's tasked with that job of figuring out what went wrong with an airplane had to say about this unfortunate act.
The motion eliminates granted.
Yes, Your Honor. Yes, Your Honor. Finally, as you're aware, the FAA is not a party to this case, and they have not been designated as a responsible third party. Because of this reason, we would like to exclude any argument that the FAA or the flight operator, Mr. Alex Bell, is liable or negligent in any way of bringing about this result.
Response to that?
Yes, Your Honor. Alex Bell, we're not lunging any fault onto Alex Bell in the form of a responsible third party. We're simply stating that actions he took alongside with Zeke Fortenberry that night helped contribute to Mr. Fortenberry's accident, as opposed to solely lunging it onto defendant Thomas Thompson. The actions of Mr. Bell in that ATC with the FAA was a form of intervening cause that contributed to Mr. Fortenberry's crash outside of the control of Mr. Thompson.
Anything further? Yes, Your Honor, the jury won't be able to make that determination when they're finally asked who's negligent because Piper Aircraft will be on that jury verdict form. Mr. Fortenberry, the deceased, will be on that verdict form, and T-Bone Thompson will be on that jury verdict form. The jury will not be able to apportion any fault to the FAA, so any arguments that they are liable is just not relevant, Your Honor.
Who's going to deny that motion?
Yes, Your Honor. Nothing further from the plaintiff.
All right. How about the defendant? Motion's in limine?
Yes, Your Honor, we have a motion in 2 parts. This case is about a pilot who failed to perform the proper calculations and the proper protocols in order to get his plane safely from one destination to another, and it caused for his plane to crash on our client, Thomas Thompson's private property. There is an email, Exhibit 4, if you would like to look at it, Your Honor, that discusses Thomas Thompson emailing his employee about line item expenses on the runway in question. Your Honor, we wish to exclude this email because we find that it's unfairly prejudicial. This email happened a month and a half before the accident. We don't know what exact line item expenses are being discussed. The word PAL isn't even mentioned, and we feel that the jury, by reading this email, will come to an opinion based on the proper basis.
Response?
Yes, Your Honor, it says the line item expense. She showed me what the line expenses are. Can't we rein this thing in a little? Our entire contention in this case is that the defendant didn't take the required remedies that were within his disposal to fix these pilots. In this case, he is directly saying what his motivations are and not repairing the runways because they're too expensive.
Your Honor, may I respond? He doesn't give a direct order saying we must cut these specific things from the runway. He's specifically asking, can we rein this in a little? Meaning he's wanting to spark a conversation about the budget regarding the runway. The word POW, the lights on the runway aren't mentioned, and to put this in front of the jury as if it is some form of evidence that he cut expenses regarding the POW system, again, is unfairly prejudicial.
Defendant's motion will is granted on the first issue. What's the second?
Yes, Your Honor. The second involves a stipulation, stipulation 18, Your Honor, if you'd like to turn to it. Stipulation 18 discusses the POW system being repaired in November, a few months after the accident in question. The stipulation states that a contractor came out the Wednesday before Thanksgiving, and he was able to, I'm sorry, I apologize. The contractor was called on the Wednesday before Thanksgiving, and that contractor was able to come out the following Monday to come repair the system. It only took one day to make it operational again. Your Honor, this violates this, the evidentiary rule concerning subsequent remedial measures.
Response?
Your Honor, we have no intention of going into subsequent remedial measures. The only thing is if the defense opens the door and asks their own witness to say, was it possible for you to get these lights fixed in 10 days? They say no, I believe then we would be able to approach you and discuss this matter further.
May I respond, Your Honor? I think that may be a little, too far there, because the time period in which this happened over the Thanksgiving holiday after the accident in November, where there's more time availability for a specific contractor to come out, and that since that accident happened, there's a more detailed focus to the runway as opposed to what's the normal course of business on that runway. We find that the jury is going to be able to conflate these circumstances pre-accident and post-accident and think that the days required to fix the system are similar.
I'm gonna grant defendant's second motion. Are we ready for openings?
Yes, Your Honor.
Yes, Your Honor.
Let's proceed with the plaintiff's opening.
Just give me one.
I'm impressed. The technology works in this world.
Some judges get funding, others don't.
Is that what it is?
It's on everywhere except for that.
It's coming on.
We got ours here.
Y'all see it over there?
Yeah.
Do you mind if we start with one of the projectors?
It's up to you. Working. It shows the speed on my, it's blinking.
But Your Honor, in your screen, if you do you see my hand right now?
Yes.
Okay, perfect. That's all.
May it please the court. He still had time to land. Still had time to land. This is a story about a pilot in an emergency. It's a story about a pilot who relied on an emergency system. A pilot, story about how that emergency system failed him in his time of need. It's a story about how the defendant's negligence caused the death of Zeke Fortenberry. Before I get into the facts of the case, let me tell you about Zeke Fortenberry. My name is Timothy Williamson. This is my co-counsel, Kusha Jamali, and we're here representing Madeline Fortenberry and the estate of Zeke Fortenberry. Madeline Fortenberry is Zeke's wife, now widow. Let me tell you about their marriage. They were coming up on their 3-year anniversary. They were traveling the world together. They built a house right here in Houston to live in together. They were trying to have a baby. They were planning a family together. IVF, adoption, natural birth. They were trying to build a life together. And that life was stolen from them on August 22nd, 2021. Now that night, Zeke Fortenberry, a pilot, was helping his friend move an airplane from one airport to another. Due to some miscalculations while he was in the air, Zeke Fortenberry runs out of gas. But he still has time to land. So he does what a pilot's supposed to do. He calls air traffic control. You're going to hear today from Alex Bell. He's the air traffic controller who spoke to Zeke Fortenberry on his last night of life He's the last person who ever spoke to Zeke Fortenberry. He's going to tell you how he directed Zeke Fortenberry to the South Fork Ranch. The South Fork Ranch is owned by the defendant, T-Bone Thompson. Now, you're going to hear one of the reasons that he was directed to South Fork Ranch is because it has what's known as a PAL light system, pilot activated lighting system. The way it works is the pilot, while they're in the sky, will take a microphone and click it 3 times. And that's supposed to turn on the runway lights automatically without anyone on the ground doing anything. Now, Zeke was flying at nighttime. The evidence will show that he was flying on the night of a new moon. There was no moon in the sky. The evidence will show you that while he's talking to Alex Bell, he tries these lights and nothing happens. The evidence will show he tries clicking like a madman. Nothing happens. Eventually, he has to cut off the call with Alex Bell because it gets too close to the ground. The next time Zeke Fortenberry is seen or heard from again is in a crash. And I want you to observe the crash that occurred. This plane didn't just end up 2 feet from a runway. This plane is in the middle of a bunch of trees in a forest because Zeke Fortenberry was trying to land blind. Now, you might be wondering how Thomas Thompson, T-Bone Thompson defendant fits in all this. As I mentioned earlier, he owns the South Fork Ranch. He's responsible for those PAL lights. And he actually took a government grant when he paid for those PAL lights. You see, and that government grant didn't come for free. It came with conditions, 3 conditions. He had to maintain the runway, the PAL lights. But if the PAL lights were broken, 2 more conditions existed. He had to fix the PAL lights within a reasonable amount of time, and he just had to notify the FAA that there was an issue. Just tell them. We're going to bring in an expert today, Sam Williams, and he's going to tell you about those requirements. And you're going to hear how notifying the FAA is a simple call. 1 call would have met that notification. Come to find out, the evidence will show T-Bone Thompson knew about these issues with the PAL lights for 10 entire days. For 10 entire days, he didn't pick up the phone. Not on day 1, not on day 2, not all the way until day 10, when Zeke Fortenberry lost his life. Now, I want to tell you about what happened when Zeke Fortenberry crashed. In that crash, he's not immediately dead. He's conscious. The evidence will show that he was going through certain horrific injuries while he was conscious in that plane for 5 to 7 minutes. I'm going to list some of them off for you. Broken leg, broken arm, spinal trauma, cracked skull, a ruptured spleen, and a punctured lung. All of that at once for 5 to 7 minutes until he ultimately fades into unconsciousness and dies. And that picture you saw earlier, that picture of the lovely couple, that was the closest person to Zeke Fortenberry. That picture, the evidence will show, was actually with him. He had that picture on him that night. He was alone. That was the closest thing he had to anyone around him, was a picture of his wife. So now we're here representing Madeline Fortenberry. We can't give her back her husband. We can't give her back pictures like that or the family they were going to build. But we can ask for some damages. We can ask for damages for that 5 to 7 minutes of suffering and the suffering of just trying to land a plane in the night, knowing that you might die. We're going to ask her for the damages for the mental anguish she went through for all this, for having to pay for her husband's funeral all on her own. And ultimately, we ask you, the jury, to remember one crucial fact. Regardless of any emergencies that were happening in the sky, regardless whether he was out of gas or anything, he still had time to land. He was in an emergency, and he relied on an emergency system that failed because of negligence. And that's why we ask you, the jury, to do what the evidence suggests and justice demands. To find the defendant, Thomas Thompson, is liable for the death of Zeke Fortenberry. Thank you.
May it please the court. His fate was sealed when he ran out of gas. Because Mr. Fortenberry did not properly fuel his plane, he's no longer with us here today. Now, ladies and gentlemen of the jury, my name is Jacob Resendez, and I, along with my co-counsel, Mr. Avon Lathrop, are proud to represent defendant Mr. Thomas Thompson. Now, Mr. Thompson is a businessman. He owns a chain of barbecue restaurants in small town Paradise, Texas. Mr. Thompson has a love of food, of his community, and of bringing his community together to share that love of food. Mr. Thompson is also a ranch manager, and he owns this ranch and where he regularly entertains his family, his friends, and his guests. But members of the jury, this case is not about Mr. Thompson. This case is about the actions and the inactions of Mr. Fortenberry on that fateful night. Now, on August 22nd, 2021, Mr. Fortenberry arrives at Kansas City, Missouri airport. He's there as a favor for a friend, a Mr. Chris Jensen. Now, Mr. Jensen had asked Mr. Fortenberry to pilot his aircraft from Kansas City, Missouri, all the way to Dallas, Texas. Now, Mr. Jensen's aircraft is a single-engine Piper jet. Now, what that means, ladies and gentlemen of the jury, is a single-engine jet means there's no backup in case of an emergency. The commercial airline pilots that you and I and our loved ones transport on regularly have multiple engines in case of emergency. Now, Mr. Fortenberry, as an experienced pilot, goes through his pre-flight checklist. Now, this is a fact that neither I nor the plaintiff will dispute. Mr. Fortenberry was an experienced pilot. Even past that, he was an instrument-rated pilot. Now, what an instrument-rated pilot means is they can pilot an aircraft simply using the instruments on their cockpit dashboard. They don't even need to see out the window. Now, again, Mr. Fortenberry, as an experienced pilot, goes through his pre-flight checklist. He checks the weather. In fact, he checks a local TV Dallas reporting news station to get his weather. He does not, in fact, check the National Oceanic Atmospheric Weather Recommendation Report that shows both the ground and surface air, both the ground and atmospheric winds. Mr. Fortenberry hops into his Piper Signet. He takes off on his journey to Dallas. Again, a 480-mile journey. Mr. Fortenberry embarks on his journey to Dallas. He makes it in a massive 430 miles along his trip before he finally realizes. Now, in the cockpit of a Piper Signet jet, there is both a fuel gauge on the right and left-hand side. Now, what this means is a fuel gauge for you and I, in terms we understand, is like a car engine. It's like a gas tank in our cars. It shows us the distance we have until we reach empty. Now, Mr. Fortenberry had access to these fuel gauges for 430 miles. Now, as an experienced aircraft pilot, Mr. Fortenberry radios in air traffic control. He reports of an emergency landing because he has run out of fuel and is experiencing engine failure. Mr. Fortenberry reaches a Mr. Alex Bell, who you will hear from today. Now, Mr. Bell advises Mr. Fortenberry to land at a small private airstrip called South Fork Ranch. Now, Mr. Bell does not advise Mr. Fortenberry of any possible alternative landing solutions. He simply wishes him good luck and that we're counting. Members of the jury, today this case is about the controllables. It's about the things that Mr. Fortenberry had control over both before his flight and during.
Your Honor, I apologize, but I have to object. In his opening, he's violated one of the MILs. Normally I'd let him finish, but he's blatantly violated the MIL about the FAA. And he's already started talking about how they could potentially be responsible. I think normally I would never do this, but I feel like I have to for the sake of the jury's interpretation of facts.
If I may respond, I'm not asserting that Alex Bell was liable for negligence in this case. I'm simply stating what the deposition of Alex Bell will show that he didn't advise a possible alternate landing solution. I didn't present it in the context of Alex Bell being negligent in this case.
Why don't you move on?
Okay. Now, members of the jury, this case is about the controllables. It's about the things that Mr. Fortenberry had control over both before and during his flight. Now, during the proceedings of this trial, you will hear from both expert and witness testimony. One of these experts is a Mr. Sam Williams that we anticipate the plaintiff will call, and Mr. Williams will attest to the fact that Mr. Fortenberry's fate was sealed when he ran out of gas. Now, members of the jury, we are confident today as the defense that we will prove to you that the plaintiff will not be able to meet this burden that they have before them today. The plaintiff's burden is to prove that the defendant, Mr. Thompson, had a duty to Mr. Fortenberry, that he breached that duty to Mr. Fortenberry, and that his breach was the proximate cause of Mr. Fortenberry's injuries. We are confident today here as the defense that you will see that the evidence suggests and that the jury demands that you return a verdict to find Mr. Thompson not liable for Mr. Fortenberry's damages. Thank you.
Thank you, sir. It's a plaintiff, ready to call the first
I
witness.
apologize, Your Honor. May I constructively approach outside the presence of the jury?
Sure.
I just want to make sure I understood the plaintiff's, what your first ruling on plaintiff's MIL motion regarding the investigation report. Is that excluded entirely or just the probable cause section on the back like they originally asked for?
As I understood it, we only discussed the probable cause.
Okay, because I thought you said probable cause or exclude entirely. I just want to make sure I may have misheard.
So sections 2.1 and 2.2, the probable cause section and the section right behind it helps with the facts. Is that correct?
No, the only probable cause section is only mentioned in your.
Well, I mentioned the probable cause section in the section report because it talks about the facts that the probable cause section applies.
The motion is only granted as to the probable cause section.
Yes, Your Honor.
Your Honor, if I may ask one more thing, given the nature of the MIL, can we get a constructive instruction to the jury to disregard the statements about the FAA and potential to navigate into some other ranch?
Workplace is clear.
Thank you.
Is the plaintiff ready to call the first witness?
Yes, Your Honor. The plaintiff called Mr. Alex Bill to extend.
Mr. Bell, I will remind you that you are constructing.
Yes, Your Honor.
May I proceed, Your Honor?
You may.
Good afternoon. Good afternoon. Could you please introduce yourself to the jury?
My name is Alex Bell.
And Mr. Bell, what do you do for a living?
I work as an air traffic controller at the FAA, Federal Aviation
Administration. What does the FAA do?
Well, as an air traffic controller at the FAA, my job is basically to make sure that planes are taking off and landing at the correct time and safely. I'm making sure that they're not running into each other. I have screenings, I have information as to where flights are at different times.
And what do you do on a day-to-day basis, beyond the standard safety work that you just mentioned?
So beyond that, there's always emergencies that arise, and we are basically the first line of defense. Whenever an emergency arises, a pilot will call in to the FAA and we will help resolve whatever emergency.
We've heard about PAL lights before. Have you heard about a system like that?
Yes, we're very familiar with them. PAL stands for Pilot Activated Light.
And could you explain to the jury what it is and why it's important?
Yes, so a PAL light, these are basically automatic lights on a runway to where when a pilot is flying over this runway and clicks a microphone a certain number of times, these lights will turn on automatically.
Now, I want to shift your attention from what you do on a day-to-day basis and what these PAL lights are to the incident in question today. Do you know Mr. Fortenberry?
Not personally, but unfortunately, I believe that I was the last person.
And is he the person on your screen in front of you?
Yes, he is.
How did you first get to know of Mr. Thornberry?
So a little bit before midnight on the night in question, I got an emergency call from Mr. Fortenberry.
Did you come to understand why Mr. Thornberry was in an emergency to begin with?
Yes, as soon as we came into contact, I learned that his engine had stopped working.
And now, do you know why his engine stopped working?
Yes, it appears that he ran out of gas.
Would this have placed them in an emergency situation based on your standards?
Yes, running out of gas or engine turning off, this is definitely to the level of an emergency situation.
So what did you instruct him to do?
So once I found out that he was in an emergency situation, as an air traffic controller, my job is to find where can he land safely. Basically, that's the only thing we're looking for. And I was able to locate where he was, which was around 50 miles north of Fort Worth. And based on that, I found an alternative runway that should have been a suitable option.
And what runway was this?
This was on South Fort Branch.
Is that the defendant's runway?
Yes, it is.
Out of all the places in the world, why did you tell him to go to that one?
The runway on South Fork Ranch seemed like a great option. Like I mentioned, it was dark outside and I could see on my system that it was supposed to have these PAL lights. So I was definitely looking for a runway where we could turn on lights automatically.
On your screen, did it show you anything about these lights not being able to be turned on?
No, absolutely not. If I were able to see that the lights were not going to be turned on, then I definitely would not have sent it there.
Do you understand that you are the last person who have spoken to Mr. Thornberry?
Unfortunately, yes.
Do you know that that crash that you had with you, there's a transcription of the conversation between you and Mr. Thornberry, right?
Yes, I remember the transfer.
Did you review it before this case today?
Yes, I did.
Do you still remember how Mr. Thornberry sounded when you were on the phone with him?
Yes, from the start, when I started talking to him, we were communicating back and forth on his elevation levels. And he was just counting down, almost like a clock, his elevation levels. His voice was shaking. I could tell he was just terrified. And as the situation unfolded and wasn't able to turn on the lights, you could tell he was getting more scared as it went on.
And how long was he circling around that runway?
He was gliding around the runway for around 5 minutes.
Was this while his engine was out of fuel?
Yes, this was while he was out of fuel.
Was this while his engine had stopped working?
Yes, you'd be surprised how often engine stops working and a plane is able to glide and maintain altitude for a certain amount of time.
So did he still have time to land?
Yes, he did.
Thank you. No further questions, Your Honor.
Defense have any questions for this folks?
Yes, and cross-examination. Good evening, Mr. Bell.
Good evening.
Mr. Bell, on the day of the wreck, you were employed as an air traffic controller, is that correct?
Yes, I was.
And an air traffic controller, that's an important job, is that correct?
Yes, sir.
And now lives are at stake when in your duties and responsibilities as an air traffic controller, is that correct?
Yes, sir.
And so you would agree that it's important as an air traffic controller with lives at stake for an air traffic controller to be alert on the job, is that correct?
Yes, I would agree. It's important.
You would agree it's important to be present on the job,
Yes,
awake even on the job?
I would agree. Yes, I think it's pretty important to be awake as an air traffic controller.
So Mr. Bell, let's start with how long you were working that day of the accident. Your shift started at 7 a.m., is that correct?
Yes, it did.
And you had been working a double shift the night that you spoke to Mr. Fortenberry, is that correct?
Yes, I was picking up a shift for a friend.
Objection, Your Honor. May we constructively approach? Your Honor, not just once in opening statements, now for the second time, you're violating the motion of limine that you granted about them pointing the fingers at the FAA. At this time, we have to ask for a mistrial.
Mr. Questions to
So, Mr. Bell, by the time you spoke to Mr. Fortenberry, you had been working for 16 hours straight. Is that correct?
A little bit under, but yes.
And you're aware that a federal aviation requirement limits air traffic controllers to only working 10 hours per day consecutively with no breaks. Is that correct?
Yes.
Now, Mr. Bell, moving on to your conversation with Mr. Fortenberry. Mr. Fortenberry, when he radioed into you, he reported engine failure, not fuel exhaustion. Is that correct?
Yes, he did. But in this case, it basically has the same effect.
And so Mr. Bell radioed you when he had already flown 430 miles and was completely out of fuel. Is that correct?
I didn't know it at the time, but yes.
So he didn't radio you before he ran out.
No, he radioed me when his engine stopped working.
Right, because as you attested on direct, he had been piloting for 5 miles without fuel. So he did radio you once you had already ran out of fuel. Was that correct?
Well, I'm not sure how long he had been flying without fuel, but I just know that his engine stopped working when he called him.
Mr. Bell, are you aware that a Piper Cygnet jet has 2 fuel gauges, both one on the left and right-hand side of the cockpit?
Yes, sir.
And so did you ever advise, or excuse me, it's true that you never advised Mr. Fortenberry to report to you what either of those 2 fuel gauges said on his cockpit?
Sir, could you repeat the question?
Is it true, Mr. Bell, that you never asked Mr. Fortenberry to tell you what either of those left or right fuel gauges said in his cockpit?
When we last spoke in my deposition, I thought I had, but after reviewing the transcript, I realized that I did not ask him about his fuel gauges.
So that's a yes, you didn't advise him to read his fuel gauges to you, is that correct?
No, I did not. But when an engine stops working, the amount of fuel is not relevant.
Mr. Bell, are you aware that even though, as the defense asserted in their opening, that the Southport Ranch was set to only 3 clicks, that the Southport Ranch is set to 7 clicks? Are you aware of that?
Objection, Your Honor. They invoked the rule. They had the witness step out. He hasn't heard the opening statement.
Mr. Bell, were you consulted on the NTSB's preliminary findings?
I'm not sure consulted, but I reviewed it.
Mr. Bell, have you ever piloted a plane yourself?
No.
And what do you hold your master's degree in, Mr. Bell?
Art history.
No further questions, Your Honor.
Briefly direct. Could you tell us about your educational past?
Yes, I went to UT Austin and got my degree in aeronautical engineering. So,
Thank you. No further questions.
Just with the step down.
please.
William Colder, I just.
Yes, Your Honor. The plaintiffs would like to call Sam Williams to the stand.
Yes.
Your Honor, just to bring it up once again, are we formally attendant hearing experts, or is it, how would you like us to go about that? You can bring that up. Good afternoon, Mr. Williams.
Hello.
Could you introduce yourself to the court?
Yes, my name is Sam Williams.
What do you do for a living, Mr. Williams?
These days I am an accident reconstructionist. I've been doing that for about 10 years.
What is accident reconstruction?
We come in after an accident has already taken place. We attempt to sort of break it down and figure out how it happened in the first place.
And before you were an accident reconstructionist, where'd you go to college?
I went to Texas Tech, where I got a degree in animal husbandry, but I minored in mechanical engineering. I've never used the animal husbandry degree, but I also got a master's from Rice in mechanical engineering.
And when you finished that master's at Rice, did you immediately go into accident reconstruction?
No, sir. So I spent about 10 years working for a private firm where we designed highways, bridges, and airport runways.
Now, I'm going to ask you about your expert witness history. Have you ever testified as an expert in court before?
Yes, sir, I have.
And have any of those testimonies been in Texas?
All of them have been in Texas.
And how many of those had to do with airplane accidents specifically?
Of about the 60, 18 have been about airplanes.
Now, have you reviewed the materials of this case?
Yes, sir, I have.
What materials did you look at when you were coming here?
So I looked at the entire case file. I looked at all the depositions. I looked at the exhibits, and I looked at the Unicom system on Mr. Thompson's runway law.
Now, when you were coming to these conclusions, did you use sound scientific principles?
Yes, sir, I did.
Are those principles used regularly in your field?
Yes, sir, they are.
Your Honor, at this time, I'd like to formally tender this expert as an expert in accident reconstruction.
Is there any objection?
There you go.
You may proceed. He's an expert.
How did Zeke Fortenberry die?
Zeke Fortenberry died because he could not see the ground when he was trying to land his plane.
Did you look at the actual evidence of the accident?
Yes, sir, I did.
Did you get a good look at what the accident looked like?
Yes, sir, I did.
Would you be able to recognize it if it was front running?
Yes, sir, there's a photograph of it in the case file.
Your Honor, at this time, I'd like to approach the witness Elizabeth Martin's Exhibit 5 and pre-admitted Exhibit 5.
You may.
Could you explain what's in this picture?
Yes, so this is a photograph of Mr. Fortenberry's plane after it went down and crashed on Mr. Thompson's ranch.
Where is that plane?
It's in the middle of a forest.
How does a plane end up in the middle of the forest?
Pilot can't see where to land.
I'm gonna ask, when this plane crashed, did Zeke Fortenberry immediately die?
No, sir, he did not.
Was he conscious?
Yes, sir, he was.
And based on your expert findings, what injuries did he go through?
Mr. Fortenberry was conscious for approximately 5 to 7 minutes after this crash. In the crash, he sustained an injury to his head, spinal injury as well. He broke his right arm, fractured his left leg, punctured his spleen, and he punctured his lung.
Were any of Mr. Fortenberry's personal belongings recovered in the case?
Yes, sir, they were.
What specifically was recovered?
There was a photograph of Mr. Fortenberry and his wife recovered from the accident.
And at this time, I'd like to approach the witness Elizabeth Martin's Exhibit 14 and pre-admitted. Who are the people in that picture?
That is Mr. Fortenberry with his wife, Madeline Fortenberry.
Now, I just want to clarify, was there anyone with Zeke when he crashed?
No, he was alone.
Through the entire thing?
Yes, sir.
What was the ultimate cause of that crash?
Cause of the crash was the fact that the POW lights on the runway were not working.
Now, why was Zeke making an emergency landing in the first place?
He had run out of fuel because he had miscalculated the amount of fuel that he would need for this flight.
When you said the ultimate crash was the POW system not working, how are both of those things true?
POW system is designed for an emergency situation. It's why the federal government gives grants to build these POW lights. You don't get to pick and choose your emergency situations. Mr. Fortenberry had an emergency situation. He needed a place to land. He should have been able to land on the ranch.
What is Thomas Thompson's involvement in this accident?
Mr. Thompson owns the ranch, South Fork Ranch, and the runway that is on that ranch.
Based on your expert findings, how did he pay for that ranch?
Well, I'm sure he paid for the ranch.
Sorry, not the
himself.
ranch, the runway.
So he paid for the runway, but he installed a pilot-activated lighting system on that runway using federal funds.
Now, do those federal funds come with conditions?
Yes, sir, they do.
What are those conditions?
The first condition is that you have to maintain the lighting system, right? Because it's important. The second requirement is that if that lighting system breaks, you are required to notify the FAA so that pilots can be rerouted elsewhere. And the third requirement is that you have to fix it within a reasonable amount of time.
I want to ask you about that second requirement. How do you notify the FAA that the POW lights are not working?
pick up the phone, call them, go on their website, send an email.
Specifically the phone call. How long does that take?
An afternoon, it's a government agency, we can call it 2 hours.
So now, did you discover in your research of this case that Thomas Thompson knew about the lights not working before the crash?
Yes, sir, there was an email that indicated that.
Objection, Your Honor, hearsay.
Closing party statement. Now, how long ago, how much time before the crash was that email?
10 days before the crash, Mr. Thompson sent an email to his ranch manager indicating that there was a problem with the power lighting system.
And so can you make that call on day one?
He could have made the call on day 1, yes, sir.
Could he have made that call any of those days, from day 1 to day 10?
He had 10 days to make a call. He could have done it during any of those days.
Let me ask you a few more questions about the actual accident that happened that night. When that emergency happened in the sky, did Zeke Fortenberry still have time to land?
Yes, he did. Planes do not fall out of the sky when they run out of fuel. They're able to glide for several minutes.
And in your expert opinion, if that PAL light system would have worked that night, what would have changed?
Mr. Fortenberry would have been able to see the runway.
And what would have changed if he could have seen the runway?
He stood a much, much better chance of actually being able to land his plane.
No further questions.
May I proceed, Your Honor?
You may.
Hello, Mr. Williams.
Hello.
You'd agree that when Mr. Fortenberry's plane ran out of fuel, his fate was sealed?
In that his plane was going to start descending. Yes, sir, absolutely.
It's a pilot's duty to make sure their plane has sufficient fuel, right?
Yes.
It's a pilot's duty to make sure that it's a pilot's duty and a duty imposed by the FAA that a pilot have enough fuel to make their destination in an additional 45 minutes of flight time, right?
Yes, that's correct.
Now, let's just talk about Mr. Fortenberry and his plane real quick. Mr. Fortenberry, on the night of the accident, he flew a Piper Cygnet in the air, right?
Yes, that's right.
And that Piper Cygnet was owned by his friend Chris Jensen.
Yes, it was.
And that is a single engine Piper Cygnet,
Yes,
meaning it only has one engine, and if it runs out, there's no other engine to keep the plane running.
that's right.
This was a 57-year-old Piper Cygnet, right?
At the time, it was close to that. Not
Right. Yeah, I apologize. At the time of Mr. Fortenberry's accident, the plane was 57 years old, right?
Somewhere around there. Yes.
Now, you heard Mr. Bell's testimony, right?
I did.
Let's kind of walk into this cockpit of this Piper Cygnet and just get a better picture of what Mr. Fortenberry was saying. Mr. Bell stated in his testimony that this Piper Cygnet had 2 fuel gauges, right?
It did.
A fuel gauge to the left
Yes.
and a fuel gauge to the right.
Objection. Sorry, Your Honor. We invoked the rule. There's no indication that he heard past testimony. So this question about what Alex Bell said during his examination, there's no indication that he would have heard any of that.
Your
Objection sustained.
Oh, I was gonna ask if I could respond on it. Okay. The Piper Cygnet has 2 fuel gauges, right?
Yes, sir, it does.
Has a fuel gauge to the left
Right.
and to the right, right?
Yes, sir, it does.
And this is in the cockpit within the view of the pilot.
Yes, it is.
Mr. Fortenberry that night was set to fly 480 miles straight line, right?
That was a straight line distance. Yes, sir.
Yes, sir. And that was from Kansas City, Missouri to Dallas, Texas.
Yes, it was.
When he crashed his airplane, he flew about 430 miles away. So he was about 50 miles short of his destination, right?
That's right.
When he radioed into Alex Bell, he had been in the air for over 4 hours, right?
Yes, he had.
So during the course of his flight, Mr. Fortenberry at any time could check either his left fuel gauge or his right fuel gauge, right?
That's right.
He could have radioed Alex Bell 10 miles before his plane ran out of fuel, right?
He could have. Yeah.
Even 5 miles, he could have ran out of fuel, right?
5 miles, he could have ran out of fuel.
I apologize, 5 miles. He could have radioed Mr. Bell 5 miles prior to running out of fuel, right?
Sure, he could have radioed him at any time.
And when a pilot is deciding how much fuel to place in their tank, there's things to consider, right?
Yes, sir, there are.
There's things in the manual, the pilot needs to know.
Things in the.
I apologize. Let me step back. There's things about a plane in terms of how much fuel he needs to carry, a pilot needs to know, right?
Yes, sir, that's right.
He needs to know the cruising speed of his plane.
He does.
He needs to know how much fuel his plane burns per hour.
He does.
And a pilot should also take into consideration weather conditions he'd be flying into, right?
Yes.
Your Honor, may I press the witness? I'm handing you what's been pre-marked as Defense Exhibit 1. We didn't pre-mint this, right, gentlemen? Exhibit 1.
Your Honor, we didn't pre-admit this, and in fact, can we constructively redact the last page of the exhibit as we've
I
discussed?
was not using the last page for these purposes, Your Honor.
Your Honor, but when he admits the exhibit, if we don't redact it, the entire exhibit.
We will reject the last page.
Okay, Your Honor.
Otherwise, it's.
Thank you, Your Honor.
Now, Mr. Williams, I'm handing you what's been pre-marked as Defense Exhibit 1. Do you recognize that document?
Yes, sir, I do.
And without getting into the contents of that document, what is it?
It's the NTSB report that was conducted after the crash.
And did you review that document in preparing for your testimony today?
Yes, sir.
And is that a true and correct copy of the NTSB report you reviewed in preparation of your testimony today?
Yes, sir, it is.
Okay, thank you, Mr. Williams. Now, Mr. Williams. Now, Mr. Williams, if you turn the page, you will see a section called Section 2 Conclusions, right? You have to turn the page a couple times.
Yes, sir, I do.
And under that is a Section 2.1 Findings, right?
Yes, sir, there are.
I'm going to read, and you see paragraph, there's a set list number of paragraphs. You see paragraph number 2?
Yes, sir, I do.
Okay, I'm going to read that paragraph. Prior to departure, the pilot accessed the internet website of WFAA-TV in Dallas to determine surface winds in the Dallas area, which were indicated as north-northeast at 10 miles per hour at that time. There is no evidence that the pilot accessed flight weather conditions available from NOAA prior to departure. Did I read that paragraph correctly?
Yes, you did.
And Your Honor, I apologize. May I step back? May I admit this into evidence marked as Defense Exhibit 1? Did I do
You
something?
just submitted it a few minutes ago.
Oh, okay, Your Honor.
Minus the last page, if I recall. correctly.
Okay, Your Honor, I apologize. Did I read that paragraph correctly?
You did.
This paragraph mentions surface winds. Surface winds are what we feel on the ground, right?
That's right.
Surface winds in terms of an airplane. Airplanes deal with surface winds when they take off and they land primarily, right?
Yes, that's right.
Now, you would agree that surface winds are different than winds aloft, right?
Winds aloft. Yes, that's correct.
Winds aloft are winds that may be different from surface winds because they're at different altitudes in the air, right?
That's right.
Now, you would also agree that when a pilot is flying their plane, they spend the majority of their time in the air at different altitudes as opposed to the surface, right?
That's true.
Your Honor, I'm approaching the witness with what's been pre-admitted as Exhibits 10 and Exhibits 11. And Mr. Williams, we'll start with Exhibit 10. Exhibit 10 is the NOAA weather report, right?
Yes.
And at the top of that report, it states that that is VFR at 5,000 feet, right? In the title, at the top line?
Yes, it does.
VFR stands for Visual Flight Rules, right?
That's right.
And that NOAA weather report is detailing weather in Kansas City, right?
Yes, it is.
Kansas City is where Zeke Fortenberry took off from, right?
That's where he started. Yes, sir.
Yes. And then if you look down on that page, it shows weather conditions in the air at 5,000 feet for Dallas, right?
Yes, it does.
Where Mr. Fortenberry will be landing, right?
That's right.
Now, turn over to Exhibit 11. That is the local weather TV forecast that Mr. Fortenberry relied on, right?
Yes, it is.
And that weather forecast is detailing winds on the surface, right?
Yes, it is.
You would agree that since a pilot spends most of their time in the air at different altitudes, a reasonable pilot would want to know the wind conditions they're flying into up in the air, right? Mr. Fortenberry only checked the local Dallas TV weather, right?
He did.
He didn't check the Kansas City weather where he was taken off from?
I'm not sure if he checked the Kansas City one, but I do have evidence that he checked the Dallas one again.
So there's no indication to show that Mr. Fortenberry checked winds at a higher altitude where his plane will be flying majority of the time, right?
There's no indication, no, sir.
And Mr. Fortenberry's plane fell 50 miles short of its destination,
Yeah.
right?
Yes, sir.
No further questions, Your Honor.
Three for your right, Your Honor. Mr. Williams, did you read the stipulations in this case before you came before the court today?
Yes, I did.
Would you recognize them if they were put in front of you?
Sure. Yes, sir.
Specifically, would you recognize stipulation 19?
I would recognize any.
May I approach the witness with the stipulations? Could you read for the court what stipulation 19 says?
Yes, sir. It says the experts agree that the Federal Aviation Administration regulations or the regulations of any other agency do not state that there is a specific or required procedure pilots must follow to check weather conditions. The experts agree that it is only required that they check.
And in your expert opinion, is checking the Dallas weather checking?
That's what's required by the FAA. Yes, it is.
You talked about Mr. Fortenberry's fate being sealed. What did you mean by that?
I mean that once he ran out of fuel, his plane was going down and he was in an emergency situation. That was why he needed the pilots.
When was his fate sealed ultimately?
When he couldn't see where to land his plane.
No further questions.
And this witness stepped down.
Oh, yes, sorry.
Right. You may sit down. Thank you. Point have any other witnesses at this time?
Yes, John, we do have Madeline Fortenberry by deposition. For the sake of the jury's time, could we read the stipulation, the designations in a constructive room?
The objection.
We are objecting to that, Your Honor.
Well, I believe you did have one objection to one of all the designations.
Yes, I apologize. I don't object to it being read constructively. I will object to the specific line designation.
Would you like a reminder on what ones?
Your Honor, the only lines we specifically object to are lines on page 3, lines 18 through 21. And we're objecting on grounds that they're irrelevant, and if they are found to be relevant, that their prejudicial effect outweigh their probative value.
Yes, Your Honor, page 3, lines 18, she's talking about wanting to be a mom with her husband. In this case, we are bringing loss of companionship in the past and in the future. This is directly probative of the damages we're seeking.
Your Honor, may I respond? The prospects of her being a mom are speculative at best. We don't know if any of these sort of family planning would have panned out. She isn't a mom now, and we find that this fact that she was trying at one point for IVF or even adopting is irrelevant or prejudicial.
I think the information can come in, and read it constructively as you'd like.
Yes, Your Honor, thank you. And with that, Your Honor, we just have 2 stipulations to read into the record, and then we'll call our case. The first one is stipulation number 17, the funeral expenses for Zeke Fortenberry were $37,500. And stipulation number 21 is the FAA mandates that owners of private airstrips are required to disclose a malfunctioning or inoperable pilot activated lighting system within a reasonable amount of time that they become aware of the issue. With that, we rest.
In some earlier discussions, I understand we're going to take a brief recess.
Oh, Your Honor, I was actually going to ask for a halftime motion for a judgment as a matter of law.
Do you want to make a motion then?
Would you prefer it now or after the brief recess?
Let's do it now.
Okay, Your Honor. Plaintiff failed to meet their burden of proof in terms of Mr. Defendant Thomas Thompson being the proximate cause of Mr. Fortenberry's injuries due to the fact that their expert testified the lack of protocols followed by Mr. Fortenberry when it came to checking winds in the air and not checking his fuel gauge while in the air. It's clear that no reasonable jury could find that defendant Thomas Thompson was the proximate cause of Zeke Fortenberry's injuries, and that Zeke Fortenberry's contributory negligence was the cause of his injuries.
Thank you. Any response to that?
Your Honor, I believe our expert made perfectly clear that the ultimate cause of Z. Fortenberry's death was the power lights not working, and not being able to see because of it. In fact, he went so far as to say his state was sealed when those power lights wouldn't come on. I think we've clearly explained how there's causation in this case, such that a reasonable jury could absolutely find by preponderance of the evidence that causation existed.
The motion's denied. We're going to take a brief recess. We'll come back at about 10 minutes.
Thank you, Your Honor.
Take that stuff.
You're good.
Yeah.
Oh,
You're a ninja.
like a ninja, like a loud Asian ninja.
Because we were all thinking you were the only one that said it.
Okay, all
Why
races.
is Francis jumping up on me?
That's, oh my God, that's real. The worst one is Gloria Lopez, because people confuse me for Gloria Lopez. I'm like, y'all are just like beyond race. It's just like, we just like, it's not even like, oh, you're Asian, y'all look like, it's like, you're just not white and you all look like.
So many flights have you been on since I last saw you?
None. Wait, I'm thinking aloud. None.
Bad questions to ask in this mock trial.
I know in this month.
We were talking about the accident reconstructionist of whining about injuries.
Yes,
Yeah,
they're learning. They're all
and
learning.
there's good staff. Invoking the rule, not invoking the rule, and then.
You know, that's become a very big.
An expert. Then the rule doesn't apply.
Yeah,
Yeah,
that's
exactly.
But this is how they learn. Because the final round of the last your team Judge Raw, they didn't ask to invoke the rule constructively.
Mm.
They just invoked the rule. So she sent everybody out, including the parties, and they didn't know to fight to keep the parties were allowed to stay. So I go clean up and I walk around and I see the witnesses like in the attorney ready room. Like, did the round start? What's going on? It's like they invoked the rule. Judge Raw. So literally, I was just sitting there, like nobody thought to say, "Oh, judge," because literally the witnesses were the parties and the experts.
Yeah,
So like
yeah,
everybody
yeah,
should have been sitting there.
Donna likes to prove a point.
Oh, and they now have learned
Yeah.
you don't ask constructively. And she's
Yeah.
like, I can get up and move. Yeah, 10 minutes. Right.
Here you got a guy that was so nice, was like, actually, I think you had an objection to what we were gonna read in to the record. It's like, man, oh, look at that, getting along and everything.
You said it was a bad thing.
Cats and dogs talking to each other.
It happens. It happens like that.
No,
Not really.
Well, I enjoyed my chips.
We heard about it, yeah.
Crunch.
It was his reaction that killed me. I didn't laugh at that.
Oh, shit. Where'd Mr. Hargis go? Did he leave?
He left, I think he took his team enough.
Oh, okay.
I'm guessing his team didn't.
He's only been out a couple of years now, right?
Yeah.
He's killing it.
He's really good. Yeah.
Got a little confidence in that mediation. I was like, okay, bro, I watched you try against him one round.
Talking about who?
Hargis. Hargis.
Brett Hargis.
Yeah, we came and watched him try something in mock trial a couple years ago.
We've got two of them coming, remember Jed? Country Jed?
So, okay.
He's coming on, and then you remember Gunnar Osteen?
I do remember who that is. Yeah,
I'm sorry.
just getting some good wingsies.
How many lawyers
It's
you
such an easy way to.
How many lawyers y'all got now?
That's good. That's real good. All right, we're gonna relate here. We have a moment.
We can't keep up with our one employee.
Right. Where y'all? I mean, everything is Zoom now, so.
Washington and Shepherd.
Are y'all in the same building that Tyler Flood owns? No, that's where Misty went. Misty's over there, I'm sorry, I get confused.
No. There's a brick building right on Shepherd in Washington. 3-story building. Jose leases the space.
Where do y'all live? He's always
Oh,
posting pictures of the gym all the time.
I know, Garden Oaks, right off of Wakefield.
Y'all live over by McGill Adame, guys, huh?
Yeah, let's see, who's on our street? James Rodriguez is on our street. And, Hilda Cibrian and her husband are right down the street from us too.
Yeah, I know.
They're freaking awesome house houses. Our house isn't bad. We just finished a remodel last year. And so she got that little gym. Yeah, that was a balcony that I enclosed. And then we had to sue our contractor. I got a mediation on that coming up in a few weeks.
What do you mess up?
Schedule a big part of it. He messed up some big shit. He messed up some things where I've got guys who won't quote.
Like, you need somebody to fix it, I'll bet something good. And he'll make sure it's right. He's got insurance and all that shit, but that's what he's coming to fix my, had a fucking water leak, they put a AC in, they blew the line out, came undone because like the water damage in my house.
Yeah.
My other remodel and all that. He's got a lot of lawyers in town stuff that are friends of mine and nobody's ever had a problem.
Yeah, I might take you up on that because I still have some stuff I gotta fix and got stuff that I probably won't ever fix, like crooked skylights and all. You gotta redo roofing to do that. I don't know if I'm ever gonna even touch that.
And when they put it in crooked.
His guy measured the length of the skylight, did his measurements for the opening, and didn't realize that the opening would be shorter because the skylight is English. And so he started his measurement based off the full length, and then so it's off center in the space, and then also two of them. It's hard to fix, right?
Yeah, it's like how builders, like you can go look at a new build, every single freaking light switch, every single foot is on. Miss that.
And then he flooded my first floor in demo. They let water leak. I had to fix that. Our washer and dryer relocated, caps the gas line to the old location. Rather than running that gas line to the new location, he just comes into another gas line that he finds on the floor. And now my first floor is fireplace. So I'm gonna have to open up the ceiling and, and they're gonna have to reconnect them. Big shit. And that's just what I can think of off the top of my head. But, whatever. I've done so many remodel projects. It's funny though, is that there's insurance defense lawyer mediates with sheriff.
Huh.
Just got to ask you, who the mediator is?
So I use Kim for the HEB stuff, which is fun. I find it so much. Put him in there, it makes Kim squirm. She hates being a mediator.
She likes it every now and then.
More than she wants to. She's got just enough charisma where people want to come back here. But she doesn't Kim as a mediator.
Yeah.
She's so through with bullshit that whenever a case comes to her, bullshit. Just, all right, here's my number.
Yeah.
I take mediator. I have a whole fucking mediator based on whoever the problem person is in the case that needs to get talking to. You gotta find a mediator to connect with that person. That's my trick. Who you like to be?
As a mediator?
Yeah. My can't be.
Like to be me. I'd like to meet me. I like AOP. Alcoholic care use. Great. We have our own personal case that we're mediating at the end of the month. Yeah, Aaron.
No, we're using Lunsford on that.
Yeah. Yeah, it's a legal lawsuit against our contractor on a renovation for our house. Just royally. Lunsford will be good. I'm very curious to see how she will be. I've practiced with her. I know she's good.
Use this to,
Um,
I thought initially I was one of the problem concepts.
so.
I said, cook or shop for short time.
What I was
Because the judge didn't rule to make a crap. I should have.
I don't have a real problem with her. Even when she was a Republican, on the lunch, I've had an issue with her.
Reminds me of my mom.
She's just very, follows the law, really, that's all I really care about. All the other crap. Yeah, I never really had any issue with anybody on that. And she. Except that people that didn't do their job.
Right.
I used to use Jose a lot when I was litigating more frequently. That was a lot of fun. I used to do him in person. I used to use Brian Coleman when people would agree to him only because he could get liens reduced. Way back in the day, before he started getting weird, because he got real weird. God, oh no, this was eons ago, 15 years
That's
ago.
actually a good point, is that the mediators got the lien kind of.
Yeah, we have to contacts. I call it Sullivan and Johnson or whatever. Yeah, I think so. We remember we're good Spanish speaking. So he stays
Do
busy.
you know Noe Moreno? He's just.
Busy. All three of us are pretty busy.
Those three in the office are booked out for the end of the
Yeah,
year.
December 8th is what I'm giving away right now. Just don't. No, I'm not mad at it. Yeah, it's a good problem.
I mediated the case when it was there. Young girl was coming off. And I just told the other side, like, y'all, but I don't care. I'm gonna mind control. My dad's actually an adjuster. He's a great dude.
Good.
And, they said, they were like, very nervous. And I
Okay.
was like, who's that?
Yeah,
And they're like, oh, he's in the hook causing really.
Yeah.
So we really looked at that building.
Yeah.
Yeah.
well, they do both. They do play defender. Yeah, yeah, they're good guys. He's good. He's good. Yeah, he's doing it for a long time. Probably last time I seen him was at a Christmas party. I think Colton was there too. Because Ward's office is there. Ward. Literally.
Asking about his car.
Would y'all like to
Oh, we're not done with the same day.
He was fucking shocked. Like, he was like, no. By the way, guys. He was
God. They do a lot. Like he does a lot of conversation.
Yes.
He was
Overwhelmed, yeah.
the next thing he showed the ball cat. I was just like.
Yeah.
I don't, that's a.
That didn't surprise me. He was fine on the bench. Some people have a distinct disdain for him.
Who's
It didn't bother me. Superior Court. I don't think it bothered me.
We are, Your Honor. Your Honor, the defense calls Mr. Thomas Thompson.
Ms. Thompson, I will remind you, you have been instructed in this.
Mr. And for that comes.
Project.
May I proceed, Your Honor?
You may.
Good afternoon. Can you please introduce yourself to the jury?
Hi, my name is Thomas Thompson.
Mr. Thompson, how old are you?
I'm spry 70.
And could you tell us a little about the property that you live on?
I live on a ranch out in Paradise, Texas, about 50 miles or so outside of Fort Worth.
And Mr. Thompson, what do you do for a living?
I own a barbecue restaurant. Couple of them, actually.
Why barbecue?
I like barbecue. You know, I'd like it because I could hold a pair of tongs, things comfort, storytelling, community.
Now, Mr. Thompson, I'd like to talk to you about your ranch. Do you have an airstrip on that property?
I do, yes, sir. I'm a pilot.
And Mr. Thompson, why did you want to build a runway on your property?
Well, before on my ranch, it was just a little dirt field that was there. So I decided to put a runway on it so, you know, I could land my plane and keep it somewhere.
Mr. Thompson, did you ever open up that airstrip to the public or charge for use of that airstrip?
I did not. It's my private runway on my personal property. So it was for me. If you wanted to use it, you have to have my permission.
Now, Mr. Thompson, I'd like to talk to you about the lighting system on your runway. Could you tell me about the lighting system that you have installed?
I have what's called a PAL system. You've heard it a couple of times. A PAL system.
And what is that PAL system?
I believe it stands for pilot activated lighting, where the pilot can click their microphone a couple of times and my runway lights turn on.
Mr. Thompson, have you ever used that PAL system yourself?
I did not. I would have my ranch manager come out and drive out to the runway so he could haul me back to the house. So he would turn the lights on for me.
Mr. Thompson, did any of your friends ever use that PAL system?
They did not. They never used to.
Did any of your friends, when landing on your runway, ever land at night?
Yes, they did. So I ended up putting in the runway for them because they were landing in the middle of the night. And I thought that was a little bit risky. So I put in the PAL system for them.
So your friends would land on your runway in the pitch black of night in the middle of the night?
Yes, they would.
Mr. Thompson, I'd now like to talk to you about the funding that you received for that PAL system. Did the FAA contribute any of those funds to your system?
Yes, they gave you 1/3 of the installation cost, and then I covered the rest, and then all the maintenance.
So it's fair to say you covered 2/3 of the installation cost of this system?
Yes,
Objection, Your Honor. Relevance, the percentages connected to the runway are not relevant. We know that Mr. Thompson did take a grant and the percentage of that grant is irrelevant. Response.
The percentages speak directly to the responsibility that Mr. Thompson took in undertaking the runway system.
How's that relevant to the accident?
It's relevant because Mr. Thompson took on 2/3 of the installation cost, so he took on some of that responsibility in the benefit system.
Thank you, Your Honor.
Now, Mr. Thompson, what efforts did you make to maintain that lighting system?
just I did whatever I had to do, you know, to maintain it and keep running.
Lastly, Mr. Thompson, I'd like to talk to you about Mr. Fortenberry. Did you know Mr. Fortenberry at all?
I did not, no.
Did he ever ask for your permission to land at your ranch?
No, sir, he did not.
No further questions, and I pass the witness.
Mr. Thompson, you are the owner of the South Fork Ranch, right?
I am, yes, sir.
And the runway involved in this accident is your runway.
It is, yes, sir.
And you'd recognize that runway if I showed you a picture of it.
Yes, sir.
Your Honor, I'd like to approach the witness who has been marked as Exhibit 6 and pre-admitted. That's the airstrip on South Fork Ranch, right?
It is, yes, sir.
And now I'll note that in that picture, the sun's out, right?
Yes, sir.
And the lights are on.
Yes, runway lights here in this picture are on.
Those are the same lights that the PAL system activates, correct?
Yes, sir.
And so if the PAL system doesn't turn those lights on at night, those lights aren't there.
No, sir.
And if it's night, that sun's not there.
No, sir.
So there's no other source of light in that picture that would have been present that night.
No, there are some lights out there that aren't connected to my runway.
So those lights aren't connected to the runway.
They are not, just the PAL system.
They're- They're not the runway lights.
No, sir, there are some lights out there that aren't my own.
Now, we talked about this PAL system. You heard Mr. Williams discuss the PAL system and how it works, right?
Yes, sir.
And you'd agree with his description of how the PAL light system works.
Yes, sir.
And you heard him talk about the grant you took
Yes, sir.
and how it came with conditions.
Yes, sir.
Specifically, the condition that if you knew there were issues with the PAL lights, you had to notify the FAA, right?
Yes, if I knew.
If you knew.
Yes.
And you knew there were issues with the PAL light system.
Objection, Your Honor, hearsay.
Your Honor, I haven't even established anything about hearsay. If anything, she's a party opponent. Second of all, my question had to do with knowledge, had to do nothing with hearsay.
Objection is overruled.
And you knew those PAL lights were having issues 10 days before the actual accident, right?
I did not know that they were for sure having issues.
So you knew they may have been having issues? I'm confused.
I knew that there was some problem with people being able to turn it on, but I didn't know if they were using the wrong procedure, they were clicking the wrong number of times. I just wasn't, I didn't know for sure if they weren't working.
So using your phrasing, you knew there were problems with the PAL lights 10 days in advance.
That is not my phrasing. I did not know that there were for sure problems with the pallets.
You did. Your Honor, I'd like to approach the witness who has been marked as exhibit 12. You recognize this exhibit, right?
I do.
It's an email that you sent 10 days before the accident.
Yes, sir.
And this is a true and correct copy of that email.
Yes, sir.
And you recognize this because you yourself typed and sent that email, right?
Yes.
Your Honor, I'd like to admit exhibit 12 as evidence.
Objection, Your Honor. It's both hearsay and hearsay within hearsay. The second line of the email, again, constructively without the presence of the jury, it says, it talks about a they. There's no mention of who this they is. For that reason, this is a hearsay within hearsay.
Your Honor, for the first level of hearsay, as I mentioned earlier, this is a party opponent speaking. For the second level of hearsay, they told me the runway lights wouldn't come on and when they did the click thing. That is not going to the truth of the matter. That is going to Mr. Thompson's knowledge of the issues with the PAL lights and notice that there was an issue in the first place. I'm not taking them for the truth of the matter. What's not important is the truth of the matter. The truth of the matter, what's important is that Mr. Thompson knew and had noticed there were issues with the PAL lights 10 days before.
Your Honor, if I may respond, the plaintiff's entire case rests upon this notice provided to Mr. Thompson. They're going to use this as the truth of the matter, and asserting to the jury that this is outside of that is not within, is not requiring within simply just notice of the email. So Your Honor, I'm okay with admitting exhibit 12. I would just simply ask that they would redact that sentence, that second sentence, starting with the they. Again, it's hearsay within hearsay. We don't know who the they is. We don't know if they use the proper procedures on the quick thing. We don't know what the quick thing necessarily is. It's not something that we can attest to the truth of the matter.
Your Honor, we will establish the truth of the matter in the surrounding case, and I believe the surrounding case, knowing that the PAL lights clearly had a malfunction 10 days later, I believe establishes that, but that's not what this email says.
Your Honor, if I may respond.
You may not, the exhibit's admitted.
Now, this is an email you sent on August 12th, correct?
It is.
And in this email, you say, I'm out at South Fork entertaining some folks. They told me that the runway lights wouldn't come on when they did the click thing. I need a response.
What's your question?
You said that in that email, didn't you?
I did.
And the click thing, you're aware that the PAL system is turned on by clicking a microphone while you're in the air, correct?
Yes, sir.
So you knew that there were issues with these PAL lights 10 days before the accident.
And I did not know for sure, for certain, the PAL lights were not working and they wouldn't come on. I didn't know if they were doing the correct procedure. I didn't know if they were picking the right number of times. I didn't know. So I told my ranch manager about it.
Okay. I'll move on. So in that 10 days, You never contacted the FAA, did you?
No, I didn't. I just reported it to my referee.
You heard Mr. Williams discuss the condition of notifying the FAA, didn't you?
Yes, if I knew the power lights were not working.
So I asked. You heard Mr. Williams discuss the condition to notify the FAA, correct?
Yes,
And you're aware that a simple phone call is all it takes to notify the FAA.
yes, if I know the power lights aren't working, I have to notify the FAA.
You didn't make that call when you found out.
Again, I didn't find out. I didn't know.
Now, Your Honor, at this time, I'd like to have the jury read instruction 21, just so we're absolutely sure what the condition is. The condition to notify, would that be permissible? So stipulation 21 states that the FAA mandates that the owners of private airstrips, you would be an owner, correct?
Yes, sir, it's my issue.
Are required to disclose a malfunctioning or inoperable pilot activated lighting system within a reasonable amount of time that they become aware of the issue.
Yes,
You were aware that someone couldn't operate the PAL lights that night, correct?
again, I didn't know if it was on them or misrepresenting the procedure.
I'm not asking whose fault it was. I'm asking whether you knew that they had been inoperable.
I didn't know that they were inoperable,
You just testified that someone was not able to operate them, correct?
but I didn't know if it was because they weren't doing the correct number of clicks or not, or the right procedure.
Objection, Your Honor, non-responsive. You knew that someone had not been able to operate those PAL lights 10 days in advance.
I knew that someone had an issue with turning them.
I'll take that. And in 10 days, you never called the FAA to tell them this.
No, I did not.
Knowing what you know now, don't you, Mr. Thompson, wish that those PAL lights would have been working that night?
Objection, Your Honor. This calls to the legal conclusion of the case at hand.
Your Honor, I don't see how this calls to the legal conclusion at all. I'm asking Mr. Thompson a simple question about if he wishes the PAL lights would have been working. Mr. Thompson, on the night of that accident, don't you, the owner of the PAL light system in question, wish the lights would have been working?
Of course I wish they're working. I
No
just
further
wish they
questions.
wasn't landing on my ranch.
A brief regret, Your Honor.
Mr. Thompson, the runway you installed in your ranch, you installed that for your friends to be safe, is that correct?
Yeah, of course.
And Mr. Thompson, you're how old again?
I'm 70.
So Mr. Thompson, when you hired your ranch manager, Mr. Barrett, was it your intention for him to handle responsibilities such as maintaining and repairing your ranch?
Yeah, he's my ranch manager. That was strong.
So when you sent this email to Mr. Barrett, was it your intention that Mr. Barrett seek to possibly investigate the cause of these lights?
He was my ranch manager, so he was in charge of anything and everything on my ranch. So when I sent him this email, it was my intention that he figure out what's going on, see what their issue was, if it was on them, if it was on me, anything like that.
And you regularly delegate responsibilities and tasks to your ranch manager, is that correct?
He's my ranch manager. He manages my ranch. He can fix me up in my car when I'm done planning my plane.
Mr. Thompson, in that email, do you know who the they is?
I don't know.
Mr. Thompson, do you know if the they in this email were using the right procedure of 7 clicks to activate the pilot activated lighting system?
I do not know.
Mr. Thompson, when your friends would land on your runway, as you previously testified, at night, did they ever use that PAL system when they would land?
No.
No further questions, Your Honor.
Anything further for this list?
Any questions, Your Honor, for me?
Your Honor, there's only a redirect for impeachment purposes.
Don't worry about it, Your Honor. I think.
Thank you very much.
Thank you.
Would you call your next witness, please?
I will. Your Honor, the defense would like to call Kim Bates to the stand.
All right.
Hi, my name is.
Is it Mr. Bates or Mr. Bates this time?
This kid, now it's Miss Kim Bates. It's like Superman, I'm gonna be born.
And Your Honor, prior to commencing direct examination, a brief moment to construct the well.
Sure.
Thank you so much, Your Honor. Let's see if this works.
Mr. Bates, I can tell you're already going to give me trouble.
It's awesome. I heard his whole testimony, sir.
Your Honor, this stand is a little bit fragile, and so if we can get this. Oh, no.
That's not what she's done here.
Your Honor, I just asked.
Blame it on the lawyer.
Your Honor, I just asked at one point, if we can't get this to stand on this, if my co-counsel can just hold this whiteboard for our demonstration.
We'll figure it out.
Thank you, Your Honor.
Oh, in the last one, you landed on.
It's too late on a Sunday afternoon for this, isn't it?
Absolutely.
Yeah.
We got one thing. Oh, those are great news. Oh, thank you. Sorry.
Y'all wanna try this one?
I just want to say one thing. This camaraderie has to keep up when you're actually practicing.
Of course you will,
Do we wanna try and see, this one might be a little bit better?
I'll place a bet on that.
Yes, thank you so much, yeah. I was quite impressed.
Good job.
Whoa, look at that.
I don't do.
Don't push it too hard.
And Your Honor, may you ask the jury if they can see this clearly and visibly, if that's good for them?
Jury, can you see this clearly? All right, it sounds like they can.
Yes, Your Honor, thank you. May I proceed?
Man.
Good evening, Ms. Bates. Can you introduce yourself to the jury?
Hi, my name is Kim Bates.
And Ms. Bates, before we get into your findings and your opinions, let's give the jury a chance to learn a little bit more about yourself. Well, where'd you go to school?
So I went to Columbia, where I got my degree in philosophy. Come to find out, not very helpful in getting a job. So then I went to Tarleton, where I got my degree in aeronautical engineering.
And after receiving your degree, your master's in aeronautical engineering, what'd you do for employment?
So first I worked at a helicopter manufacturing outfit for about 12 years. So I built, manufactured helicopters, and then I opened up my own consulting firm where I worked with aircraft manufacturers, the lawyers on litigation, stuff like that.
And these litigation matters, what do they typically entail?
Aircraft accident, reconstruction, investigation.
Have you ever been recognized in the court of law as an expert?
I had, yes, sir.
Have you ever been excluded?
No, sir.
Ms. Bates, have you had a chance to investigate an aircraft accident involving a pilot named Zeke Fortenberry on the day of August 22nd, 2021?
Yes.
Have you reached an opinion based on a reasonable degree of scientific certainty about the cause of that crash?
Yes.
What did you review and come into these opinions?
So everything that was available to me in the case file, I looked at all the depositions, the exhibits, anything that I have.
Did you rely on your skill, knowledge, training, and education in arriving at these opinions?
Yes, I did.
Do the methods that you rely on, are those methods also employed by other experts in your field of knowledge?
Yes.
Okay, thank you, Ms. Bates. How many opinions do you have, Ms. Bates?
I have 3.
What's your first opinion?
My first opinion is that Mr. Thompson, the defendant, was not negligent in how he maintained his PAL lighting system.
How is he supposed to maintain it?
So when he accepted the grant money for the lighting system, they told him that he had to maintain it within like a reasonable person would. He was held to a reasonable standard. He wasn't imposed any kind of strict standard. They didn't tell him like a specific time frame that he had to maintain and fix the lights. All they told him was reasonable based on his specific circumstances, the circumstances of his runway, all that.
Is that same standard of reasonability when it comes to maintaining the runway? Does that reasonable standard also apply to repairing the runway?
Yes, so he was supposed to maintain the runway like a reasonable person and then fix the runway within a reasonable amount of time once he saw the runway was broken.
Let's move on to your second opinion, Ms. Bates. What is your second opinion?
My second opinion is that the third-party defendant, Piper Manufacturing and Aircraft, I believe, are also responsible or also alternatively responsible for Zeke Fortenberry's accident.
And what's your basis for that opinion?
So at the crash site for the Fortenberry crash, there was a manual found for the incorrect plane. Zeke Fortenberry was flying a Piper Signet, but the manual found at the accident site was for a Piper Skymobile.
Now, why is this important, Ms. Bates, that a Piper Skymobile was found inside the Signet and not a Piper Signet manual found?
So the manual has all of the important numbers that a pilot needs when they're making their fuel calculations for how much fuel they're going to be needing for the distance in the trip, right? So inside the Piper Skymobile, that plane actually has a much larger fuel capacity than the Piper Signet. So Mr. Fortenberry might have thought that he had more fuel available to him in his plane than he actually did because he had the wrong manual.
In your opinion, should a reasonable airplane manufacturer ensure that the correct model for the correct plane is inside the correct model airplane?
Yes.
Would relying on that incorrect aircraft information given in the manual, would that play a substantial factor in the plane causing the plane to run out of gas?
Yes, I mean, if he thought he had more gas available to him than he actually did, then he would run out of gas.
Ms. Bates, Ms. Bates, you said you had 3 opinions. What's your third opinion?
My third opinion is that the Zeke Fortenberry accident was due to pilot error.
Ms. Bates, what's your basis for saying that this was pilot error?
Well, either he had relied on the wrong manual, or either that or he had miscalculated the amount of fuel he actually needed for his trip.
Did Mr. Fortenberry fail to calculate fuel?
I mean, we know that he did because he ran out of gas.
Ms. Bates, do you think it would aid the jury in understanding your testimony if you were to step down and perform the calculations that Mr. Fortenberry should have performed the day of the accident?
Yes.
Your Honor, permission for the witness to step down and perform a brief demonstration.
No objection?
Yes, Your Honor, this witness has already created her calculations, and they have given these calculations to us. We can just publish this and it's faster for the jury too.
Your Honor, I want the jury to see, it's not those calculations alone. Those calculations have been admitted into evidence, and I want the jury to see firsthand the mindset of a pilot and how a pilot should be calculating their fuel in real time.
Your Honor, this is not a pilot, by the way.
The witness may step down with the understanding she is not a pilot.
Thank you, Your Honor. Ms. Bates, what are the numbers that a reasonable pilot need to know in order to calculate their fuel properly?
Yes, well, while I am not a pilot, I can't tell you what these numbers are. So the first one that they're going to need to know is how much fuel their plane consumes per hour. So we'll just write fuel per hour.
Okay, and what are the other numbers as well?
So they're going to need to know the distance of their trip. They're going to need to know their fuel capacity. And finally, they're going to need to know their cruising speed.
What was the fuel consumption per hour of the Piper Signet that Mr. Fortenberry was flying?
So his plane burned 10 gallons per hour.
And what was the distance set to travel from Mr. Fortenberry?
He was traveling from Kansas City, Missouri to DFW, so 480 miles.
What was the fuel capacity of the Piper Signet?
The Piper Signet had a 45 usable gallons available to it.
And you say usable. Can you kind of explain what that means?
So I believe the Piper Signet had a fuel capacity of 50, but you can only use 45 of them. So we'll just focus on that.
And what was the cruising speed of the Piper Signet?
At 120 miles per hour, give or take the weather, because the weather does play a role in this.
What kind of role does the weather play in terms of cruising speed?
So in its most basic form, your cruising speed, this is what it is when there's absolutely no wind in the sky. But if you're dealing with the headwind, it's going to be reducing your speed. It's going to be pushing your plane back.
right? If you have a tailwind, it's gonna be doing the exact opposite. Be pushing your plane forward, making your plane go faster. The headwind's gonna slow you down, tailwind's gonna speed you up. So if there's no wind, you're at 120 miles per hour, but obviously that is not always the case. The pilot needs to know the wind.
Ms. Bates, let's put ourselves in a situation where the wind was perfect that day. There was no wind. How long would it have taken Mr. Fortenberry to arrive to Dallas if the wind was perfect? 0.
So we'll do perfect weather for this. See how long it would have taken him?
Yes.
So how long it would have taken him? So it would have taken him, so you're gonna do a really simple calculation. You have 480 miles of distance. He's traveling at 120 miles per hour. That's a 4-hour trip.
In a 4-hour trip, how much fuel is consumed by the Piper Cygnet?
So if he burns 10 gallons an hour for a 4-hour trip, he's burning 40 gallons an hour.
Is there a surplus?
Yes, so as you can see, he had a fuel capacity of 45. He's got 5 gallons left over. He would have made it to DFW.
So this is in an ideal no-wind scenario. What kind of winds was Mr. Fortenberry facing?
So unfortunately, Mr. Fortenberry was facing winds the night of his accident. I believe the accident was the 21st of August.
Yes.
So he was facing winds at about 22 to 25 knots or 25 to 28 miles per hour, and that was a headwind. So it was slowing him down.
And and since that slowed his cruising speed down, what did it slow the speed down to?
So now, I'll write down the wind is 25 to 28 miles per hour. We can meet Mr. Fortenberry in the middle. We do the exact same calculation we did here. So instead of dividing 480 by 120, we'll divide it by 93, just 120 minus 27. Now leaving him at a time to get to DFW as 5.2 hours. He added 1.2 hours to his trip.
This additional 1.2 hours a trip, what effect did that have on the consumption of his fuel?
So he's still burning 10 gallons an hour. At burning 10 gallons an hour, 5.2 hours, he now needs 52 gallons of gas in order to get to DFW.
With those winds, could Mr. Fortenberry have made it to DFW?
No, he didn't have enough gas. He was actually at a negative.
Thank you, Your Honor. Permission to have Ms. Bates step back onto the witness stand and to preserve this as a demonstrative.
Permission is granted. Ms. Bates, please return to the witness stand. Maybe.
Ms. Bates, I'm sorry, can you, the date those 20s are reversed, it's August 22nd, 2021, if you don't mind fixing that. I appreciate it, Ms. Bates. Thank you so much. Appreciate it. And Your Honor, permission to preserve this is, that's demonstrative. Ms. Bates, we talked about the importance of weather when it comes to our fuel calculations. Can you expand on that?
So again, weather is just very important. The pilot needs to understand the weather that's in the air, because that's where he's going to be spending the majority of his time.
What did Z. Fortenberry rely on to figure out what winds he'd be flying into?
There was evidence that he relied.
Your Honor, speculation. She would have no frame of reference to know what Mr. Fortenberry relied on.
Your Honor, she reviewed the case file specifically, the case file, let alone, I apologize. She reviewed the case file and she reviewed the NTSB report. The NTSB report also states that Mr. Fortenberry relied on local Dallas weather for surface winds.
She wasn't in his mind though, right?
No, Your Honor, but she reviewed the requisite materials and her along with plaintiff's own expert agreed that Mr. Fortenberry relied on the local Dallas weather.
That worded the objection sustained. Rephrase it if you'd like.
What did the NTSB find that Mr. Fortenberry relied on for weather?
So in their investigation, they found that he relied on local Dallas TV weather.
Was that reasonable of an experienced pilot like Mr. Fortenberry?
I do not believe so.
In your experience, what should a pilot be checking on for when looking at what weather they'll be flying into?
They need to be checking a forecast that is showing you the winds at higher altitudes, because that's where they're going to be. So for example, the National Oceanic Atmospheric Administration has forecasts like that.
Your Honor, may I press the witness? I'm showing you what's been pre-admitted both as exhibits 10 and exhibit 11. So counsel, if you don't mind publishing for the jury. Let's start with Exhibit 10, Ms. Bates. What is Exhibit 10?
Exhibit 10 is the NOAA weather forecast.
And what kind of weather is that forecasting?
So that's for the weather at 5,000 feet in the air from Kansas City, Missouri to DFW.
And what is it detailing throughout the evening for a pilot to rely on in terms of their flight in the forecast?
So can you repeat the question?
No problem. What is that weather, what is the NOAA weather report detailing throughout its forecast for a pilot to look at?
I mean, pretty much everything they would need to know. It's showing you the weather from their starting point to their end point, showing you the direction of the winds, the speeds of the winds, how high the winds are. Pilot would need to know this information if they're going to make their fuel calculations.
And now let's move on to Exhibit 11. What is Exhibit 11?
Exhibit 11. Exhibit 11 is the local Dallas TV weather report that was inside the case file that I reviewed.
And what is wrong with that weather report that makes it unreasonable for Mr. Fortenberry to rely on as opposed to NOAA?
Well, one, it's only showing you Dallas weather, and he started in Kansas. So he needs to know, Kansas City, he needs to know the weather in both areas, not just in Dallas. And also, it's only showing you weather that is presumably for weather for people already in Dallas, people who are there walking around. It's not showing you the weather people in Dallas 5,000 feet up in the air.
Ms. Bates, what does the FAA require in checking the weather?
All it requires is that they check the weather. It does not specify from what specific source. But again, I'll say, he's not walking to Dallas, he's flying to Dallas. We need to know the weather we need.
If Steve Fortenberry only relied on the surface winds as provided by local Dallas television, would his calculations have ever been correct?
No, because what we know now is that the winds are forecasted to be much stronger than what was here in Exhibit 11.
And how short was Mr. Fortenberry of his distance to Dallas?
50 miles.
No further questions, Your Honor.
Proceed, Your Honor. I'm Ms. Bates. Doing okay today?
I'm good.
I want to clear up a misunderstanding from a moment ago. You understand that the power lights were not working on August 22nd, 2021, right?
They were not working.
And you reviewed the entire case file, right?
I did.
And you reviewed all the exhibits and depositions and everything the defense provided, right?
I did.
And you didn't see anything that showed Mr. T-Bone Thompson fixed the POW lights within 10 days of the accident.
I did not.
You didn't see anything that showed T-Bone Thompson brought anyone out to the runway to work on anything about the POW lights on his runway, right? So T-Bone Thompson received an email, right, on August 12th, 2021?
I believe so, yes.
And he was told that the runway lights, there was an issue with the runway lights, right?
Yes.
And given that he didn't bring anyone out there to work on the POW lights, and the fact that the POW lights weren't working on August 22nd, means that the POW lights weren't working for those 10 days, right?
I mean, I don't know, because he had told us that he would, in his deposition that I reviewed, he mentioned that he was always having people come out there, maintain the lights, check on them. So I don't know if no one was out there,
Okay.
and I don't know if they were broken for those full 10 days.
And you didn't bother to call and ask, right?
I don't have any record of that, no.
Right, you didn't ask the defendant, right?
Did I ask the defendant?
Yeah, you didn't ask the defendant either,
No, I did not ask the defendant.
because it didn't matter to you, did it?
I would not say that it did not matter to me.
But nevertheless, you came here and told the jury that you don't know what was wrong with the lights for these 10 days, right?
It's not my job. I'm not a mechanic for the lights.
Right. What your job is to come here and tell the jury what happened, right?
Yes.
And you just didn't want to ask those questions, did you?
I'm not supposed to be talking to the defendant.
Is that what they told you?
I didn't talk. I only reviewed the case file, sir. That's what I told you that I rely on.
Very well. You just spoke about Piper Aircraft, and you said Piper Aircraft was negligent, right?
Yes.
You said Piper Aircraft supplied a wrong manual in this plane, right?
Yes.
And you said Mr. Fortenberry clearly relied on this manual, right?
I would assume so, because it was found in the plane. He needs the manual for his calculations.
All right, but you weren't there when Mr. Fortenberry was doing his calculations, right?
I was not,
You didn't have a camera in his cockpit while he got in his plane?
no.
You didn't talk to anyone around Mr. Fortenberry to see how he came up to his calculations, right?
Well, I would hope that he would use the manual, considering it's the only place where he can find those numbers.
So he couldn't find the manual online?
I'm sure he could, but the manual's right there in the plane.
Right, so he could have found the manual online, right?
Sure.
And you have no way of actually telling us definitively that Mr. Fortenberry even opened that manual ever.
I just know that it was found at the crash site.
You know, here, you did a lot of math for us, right?
I did,
And this accident happened about 4 years ago, right?
I did.
So you've had 4 years to be able to perfect your math, right?
Yes,
To be able to tell the jury exactly the type of math Mr. Fortenberry should have done, right?
yes,
And you're here to tell the jury that Mr. Fortenberry did the calculations wrong, correctly?
I mean, again, it would appear so because he ran out of gas.
Right, and we agree with you, right?
Mhm.
But at the end of the day, math is hard, isn't it?
Can be,
It can even be hard for an expert such as yourself.
sometimes, yeah.
Your Honor, permission to approach the witness with what's been marked as Exhibit 13. Now, Ms. Spates, you did those calculations, right?
Yes, I did.
And you did those calculations because the defense asked you, what would correct calculations look like, right?
They just wanted to see kind of how much gas he would need.
Right, so the defense paid you as an expert to come to those numbers, right?
Yes,
And we haven't altered that, have we?
you have not, no, sir.
And that's the true and correct copy that you provided us?
Yes, sir.
Permission to admit this into evidence, Your Honor?
Objection. Objection, hearsay.
Your Honor, I believe they've already opened the door to hearsay considerations, already done all the math, and this goes to the witness's credit.
All right, Your Honor, then objection cumulative.
It goes to the witness's credit. Could you pull this to the jury, please? Now, I can't see it up there, but, okay, now I can see it. Where Mr. Williamson's hand is, it says ground speed equals 120 minus 28, right?
Yes, where it equals 3.
Equals 3. Now, that's not right, is it?
It's not, these are my calculations in their, most raw form, for sure.
And some mistakes happen, right?
Absolutely,
Mistakes even happen to experts such as yourself.
they do.
And even after 4 years of you being able to sit down and look at these calculations knowing they're wrong, you still weren't able to do them correctly again up here, were you?
Excuse me?
Well, actually, if I have a marker, I can show you. You know what? I'm not going to ruin your exhibit. I'll put a post-it note up here. I'll show you. So you said 480, and then you got 93 up here, didn't you? On your exhibit?
Yes,
Okay, and you just made this in front of us, right?
I did.
I haven't played around with any of these numbers, have I?
No,
Well, you got the number 93 here, right?
I did, yes, sir.
That's wrong, isn't it?
How is that wrong?
You said you took 28.
I did not say that.
Well, this is 28 miles per hour, right?
As I said, I met Mr. Fortenberry in the middle,
Uh-huh.
and I did 120
Right.
minus 27. Between 25 and 28, come up with 93.
Okay, so between 25 and 28, you determined 27 is the number in the middle.
I picked a number in the middle. I met him in the middle.
You understand that in between 25 and 28, 27 and a half is the number in the middle?
Sure, I'm just trying to keep it easy for the jury.
Right, right. That's what you're trying to do. We can just move on past that. All I'm trying to say is miscalculations are bound to happen, right?
They're bound to happen. Yes, sir.
And that's what happened to Mr. Fortenberry, right?
Yes, he miscalculated, but then he did not check his fuel for 4 hours, which would have told him about that miscalculation.
My question was miscalculations happen, right?
100%.
And that's the whole reason why we have PAL lights, isn't it?
Because of miscalculations, I would say no. I say that they're for emergencies. And
Right.
they're for people
And
who-
miscalculations cause emergencies, don't they, ma'am?
They can.
They can. And that's why we have PAL lights to begin with, right?
They're for emergencies or people to land in the dark. Yes, sir.
Right, for emergencies. And Mr. Fortenberry was confronted with an emergency, was he not?
He was, yes, sir.
And Mr. Fortenberry was not able to turn on those lights, correct?
He was not, yes, sir.
Because the PAL lights were not working, right?
Yes, sir.
And you reviewed everything within this case file, right?
Yes.
You were not able to find anything that shows that T-Bone Thompson ever even bothered to pick up the phone and call the FAA, correct?
I did not review that.
You didn't see that, right?
I did not see it.
Because it didn't happen, right?
I did not see it in case file. So I
It
didn't
didn't,
review
it didn't happen, right?
I don't believe so.
You didn't even bother to ask Mr. Thompson yourself?
Again, just like your expert, I only looked at what was in the case file.
So you know what our expert did to come to his findings?
I looked what was in the case file, just like your expert.
Do you know that for a fact?
I was in the room when he testified and said what he looked at and relying on his opinion.
You don't know if our expert talked to the plaintiffs, do you?
I believe when you talked to your expert, you asked him what he relied on coming to his opinion.
Right?
And all he said was he reviewed the case file.
But you don't know exactly, besides reviewing the case file, what our expert did, correct?
I'm assuming that it said that on the stand. I did not talk to the defendant, no.
You didn't talk to the defendant, and it never even crossed your mind to ask the defendant, did it?
I guess not, no.
Thank you, Ms. Bates. No further questions, Your Honor.
No redirect, Your Honor, and, defense close.
Resume to our agreements. I think we're gonna take about a 10-minute break. We will resume about 4:30.
I have a quick motion before the court, Your Honor.
Absolutely.
We have Piper Aircraft designated as a responsible third party. We'd like to remove that since there has been no showing that it caused Mr. Fortenberry's crash.
Response?
Your Honor, the Piper, the wrong manual was found at the scene of the crash. No other manual was found at the scene of the crash. A reasonable pilot relies on the manual when determining their fuel calculations. Therefore, a reasonable pilot got the wrong information based on the wrong manual and made the wrong. fuel
Where's the
calculation.
evidence that the pilot relied on that?
Our expert testified that pilots typically rely on their aircraft manuals to determine their fuel calculations. This was not his plane. And he did not own this Piper Signet, therefore he'd probably be more inclined to rely on the manual that is provided inside the plane.
Any further? Your Honor, their expert just testified that he could have just looked up the manual online and never even, there's no evidence that he even opened the manual to begin.
Motion's granted. We'll take a brief recess till 4:35 and we'll take a closing. Yes, sir.
Your Honor, one last thing, when we redact the jury charge to cross out any mention of Piper?
You may.
Get started late.
Things each side.
Where's on the left?
Where are we at?
I don't know. I can try them. I'm just a spectator here.
The timekeeper.
Witnesses for.
I couldn't focus as well as.
Shut up. So my laptop, my foot. It's like, I can't.
Lost right there.
Do it.
Mhm.
Yeah, I see what I'm doing now. My I had a kid last year. He was just, all I want to do is do math. So we were like, fine. We let Kyle do math. I'm like, you do it. You explain it to us. It went on for like half an hour. I'm like, and this is why you can't do math in a Montreal competition. Half an hour he wants to do physics. Because he wanted to prove why the expert opinion defied physics. And I was like, all right, dude, let's go. Show us why these ballers don't want to take forever. Actually, don't actually step off. You know, give good senior thing.
You better, you gotta, the trick with that is being able to convey it easily.
Yeah.
Make it make sense.
You gotta kneel to
Keep it
crest,
simple,
type
stupid.
that shit.
Keep it simple, stupid.
Yeah, that's pretty
Keep it
thing.
simple, stupid.
You stupid longhorn hat. Four. we're missing, the defense team had one that was.
My note, this is a confusing chart, I'm not gonna lie.
Always a-
I was like, I'm gonna.
They are, they're always all over the place.
We just gotta move the car by 6, that's all.
You'll be done way before.
Okay.
She's like, her back.
It's not even 5 o'clock yet. Yeah, sure.
What'd you say?
Sure, I haven't done, should pull out there because of it. The Allen part, 13 to 12. As of Friday, yes, like day one. Martin was taking me over there. It was not in her messages. You'll remember her. Do you remember she came and witnessed for MTC? Maddie, yeah.
They can object to anything.
I mean, sure.
There's no instructions like you can't object to this or that.
I was like, where's the hearsay? I was like,
Scare them.
it's like, she's on the
For
stand.
me, the trickiest part is that, and we said this before, I think the objection is becoming more and more apparent. And that we're getting more teams with the undisclosed expert opinion. Cause I was like, in my head, a couple of times, like, Lord, can this guy really be talking about that?
Yeah, that's always hard to do. The part of this that you just kind of have to get it to move along and play it out. You're not gonna kill it in the middle of the competition, like, oh, done, over.
So is Laura one of the coaches?
LGD? Yeah, right. They were a mock trial husband and wife. They were partners from the law school. And so,
Yeah, we saw them. We did the final.
yep. And so now that they are finally 3 years out.
You're 3 years out.
They get to coach.
It's been 3 years since we did this last.
No. You saw them do the young lawyer tournament. That's when you graduate. But,
It's like, dang.
it's from, yeah, if they competed in that, that's when that's.
It was.
But I don't want them to coach until they get out. I want them to go get some practical
Tell me
experience.
their names. Jacob and who?
Jacob Resendez and Avon.
Avon?
Avon, A-V-E-N.
Amen. I was like, what is his?
Avon's the closer, Jacob's the opener.
And the other two are
Kusha's gonna be the closer and Tim was the opener.
Tim and Kusha?
Mhm.
Mr. Kush.
Tim will be opener. Jacob was the. I'm just gonna refer to him as Kate.
Kusha.
Right.
Tim, Avon, and Jacob.
Yeah.
Got 'em.
It was hard. It was hard.
Oh, I'll see you tomorrow.
Lance hates the cases he gets. They're also that's the ball. It's like, well, a customer walked in front of this and like rough water like 10 seconds before.
I keep getting all of her prodigies.
Their whole face.
Doing these stupid flip ball.
Because they're,
And they want to work them up a lot.
because you know why? Because the lawyer's firm, that these PI firms, is a large mill, 13 mill. And they just, they flip it every time to their door and it's a pretty shitty case, like everything on the record. Right? It's like, there's no notice on the,
And they want to.
what do you do?
They want
It is a
to
test.
depose
It's a lot of-
five people.
And we're like, so then he's like,
I get referred to, I've taken one or two.
should be a good one.
And those parking lot death carries.
There you go.
And even there.
Yeah, that's hard. That's hard.
I did that car.
It was death carries, but the truth is, it's kind of like suing you, right?
It is.
Because you know, Sue's like,
Yeah.
you better damn good action.
The wall's
for sure.
on your side.
Not, it's on your side, and like, I got the Monday.
Everybody loves it.
Like, I
Yeah.
love the shit out of it.
Yeah.
We got,
They've got a client, they were a client of mine, 6 years, we had them 6 years.
but she became a mediator. She was so scared that it wasn't gonna pick up, that we were like, all right, let's pick up some clients, we'll get some
Oh my
clients.
God, well, when COVID happened, so we stopped doing mediation in person. And so I
Picked up
I had a couple of HEB cases before that,
You know,
easy cases, like, a couple slip and falls, a couple of products falling on people, so.
you almost got Geico.
Geico was trying to give me, Geico was trying to give me all of their animal council work. And I was like, no, I don't want any of that. So he was assistant general counsel for an oil and gas company. And then my mediation practice went like this, and then HB started wanting to say more cases, and I said,
I'm gonna quit.
quit your job, come do
I'm
this.
gonna be a litigator.
It's like, you're gonna come do some slip and fall defense, I can't do this. So we hire, he does it all, and then we have a contract lawyer who takes all the depots or whatever, yeah.
Shit, right? You're welcome before dire.
Yeah. Yeah, I mean, generally speaking,
They don't want
not as much as, every now and then, they'll try to keep the other side being like, $1 million, and it's like, there's no notice.
They will, if it's a case, if it's a get past investigative case, they'll put enough money out there where
Make a business.
if you don't take it, you don't take it as a plaintiff lawyer, you're asking for the money.
Yes. Yeah, they will.
I saw myself put on the
Where were you? After they go, shut up, I'm like, yeah. They mediate a lot with me, and I'm like, Walmart. I'm just like, how do you want this to
I should have come with a second job.
They do bad.
They do a lot of batch mediations with me, and I think they like using me because I have a lot of experience. I'm like, no, you owe for this. Like, there's the condition. Find employees want mine. It's on the ground. You can finish it. You owe for it in the Walmart. I'm like, plus, they get to meet their staff. They have that advantage. Yeah, yeah. You'd be surprised as to how many plaintiffs tell their lawyer, oh, I slipped a bill on this and da-da-da, and then the video is like, no, I don't know what it saying.
If I get a video. I was so young.
It's bad for you. It's bad for you, exactly. It ain't good for you.
So, for our cases, if I contact, if I answer, and say, hey, I got the money.
You probably wanna watch this, yeah. Your client created this bill and has committed fraud.
And we had one attorney the other day, they set the camera in my room. So, I mean, the lady still didn't know if she goes on to the certain part of it. Problem was about 20 seconds before that, some kid.
I wasn't talking to you, I'm sorry, I'm talking to Michael.
That's how much, yeah.
I know you're okay. You did just
2 or
fine.
3 out of every 10 are fraud.
Yep, yeah.
Where I got somebody stealing more.
I saw somebody do that one time when I was working in Supermall.
Yeah.
And the lady, she started screaming and hollering at me and my buddy. We watched the whole thing and we were just sitting there laughing our ass off. I was like, we saw you lay down, lady. Why are you screaming like
I
this?
don't think that there's
She just
cameras everywhere.
opposed the camera. Dude, it's fraud case. Keep watching the videos. But it was moving down.
The lawyer asked, called me and asked me to take his son's deposition because he's trying to withdraw him. He has a letter. He's like, I need you to take this guy's debt. I'm like, you can't have our contract lawyer do this. He's like, no, you need to be the one. I'm like, okay, I guess I'll do the labor fund.
We got a bench trial that next Friday.
He's like, I think
That's not gonna last long. You're supposed to go, did you ever show up in front of Judge Kent down in the Maritime case down there when he was on the bench?
no. Oh, Kent, yes, I didn't.
You know, some of the Sam Kenny got put in jail and all that.
Yes,
Just on the
yes,
bench.
Gregoria, yeah.
Holy shit, if I opened your case, he would hammer you. He would
Yes.
hammer you.
I just feel bad because I love the plaintiff attorney. It's Rich Virginia. Like, it's like, I just gotta get rid of this guy. I gotta get the deductions. Okay, whatever.
Flip this around so I can see.
Oh, I want to fair
It's
have
good,
a
it's
drink
good.
with them afterwards.
And
It's
it's
like, I'm
definitely-
not taking this stupid ass shit. He's like, well, y'all.
Anthony?
Show us the video before we file a lawsuit with you. Well,
You get the.
Just got someone on the Jeff. Oh, I think you already asked me that question, so I'm going to invoke my right not to answer it
I
again.
think it's on. It looks like it's on. Yeah, it says it's on the screen.
I don't think I have to answer that.
I want to be able to follow along. with
People
it.
are so smarter than, so much smarter than everybody else in the room. It's a lot of fun.
Let's work out these technical issues that they can mean whenever they're ready.
Yeah. This is your show. You're the family of daughter on North Shepherd.
I deal with these technical issues all the time in my own courtroom, so I get it.
I'm in development and student staff, podcast.
It would be nice to know.
I mean, it is the slowest fall. You've ever seen.
It's so calculated. I'm really trying not to get hurt, but I need to look like I'm there.
It was.
This is
I
so stupid.
was like, is this on, the first time I watched this, like, is this on slow?
Is it on slow-mo?
This is regular time. Like, it was a
Oh, yeah.
10-second
No, the
fall.
people that are creating and
Five, yes,
manufacturing
I
the
believe.
balls and doing all this, they fall in a certain way. It's like, you know, whereas when you slip, you
This was such a fall into a.
in a sitting position. Yeah, it's great. It's just mostly comedy. It keeps you, keeps the belly
Way more
chuckling
entertaining than oil
than
and gas.
anything is. Anything else?
You said it.
It's not nap time yet, Cheryl.
I'm sorry?
It's not nap time.
I know, like, I need a nap. I'm not bored with y'all, I just generally am.
I got my license.
No, I understand. I got my license to practice law. And I just started Abraham Watkins as a lawyer, and I got called for jury duty in a federal case. And I was number 4 on the panel,
Oh, wow.
and the lawyers asked me 2 questions. You're a lawyer and you can be very sure. And I sat down. I said, I can't believe this. They're gonna put me on this jury. And it was a case against Briar Forest ISD by a woman that claimed to be discriminated against by the in order to apply for a job, right? And some of the testimony was so boring. And I, of course, was burning the midnight oil every night and all that. It was Christmas season and all that. So I was back there. And I would fall just dead ass asleep in the back, and the judge would stop, the trial judge Stacy, he looked at me and goes, Mr. Webster, you need to try to stay awake, sir. I'm like, I'm really sorry, Your Honor. But they asked for 300,000, we got on 678.
Dang.
But it was a good time. It was a good time to see how it works being on a jury like that.
Just finished a jury trial this week with, well, it settled in the middle of it. We got a lawyer on. He was like number 4. He didn't say anything during the word either. At all. And he was on.
I don't know how they do that.
I was a juror in Tanya's court a few years ago.
Yeah.
Car wreck case.
Direct case, yeah.
They put you on the jury?
Yeah.
I don't think they put him there. I just think that he just, you know, process of
They just
elimination.
didn't hate him.
They didn't hate him.
No, they tried. They tried to give it.
We're making progress, maybe?
It flashed the computer on it. I don't know what that means, but.
Mannerisms and. It's hard now.
Thinking of every word that's coming out of his mouth.
So sorry, I'm not yawning because y'all, I promise.
Hour and 20 minutes before.
Yeah.
6.
What'd you say?
It doesn't include objectives.
Explain.
Everything projectors.
Oh, I never watched it.
The wrong input on the computer right now, needs to go to the.
What's the time that they have?
47 minutes.
I will not use it.
We
all,
will
I
use
promise.
every minute.
I'm sorry, what? How much time do you have left
27 minutes.
collectively?
No, I have 27.
Oh, you have 27
They
minutes.
have 25 minutes. I will not use all
They
27.
said 6 o'clock, come on.
I promise you
Someone
that.
saying that.
We're parked,
No,
we're
I
parked in a
think-
spot that we have until 6. It's like 6 blocks away.
The ballet
I'm gonna be,
Free exercise.
I can't run right.
It becomes a valet for a nightclub. Further up the street.
And you're not going to the nightclub after?
Well, we're not the
Absolutely is. Don't
valet.
judge her.
We're not the valet services.
I can't run right now.
Yeah, I hope you live it around.
Let me know.
We'll be done.
Well, yeah.
First off, and turn that on. So.
The old
Just sitting there for too long, it'll just automatically turn off. Just really like.
Huh? I don't know.
The projector is definitely on, so it's over there somewhere.
They all have.
Well, they have screens in front of them.
We're good with the screens. Let's
We
go.
had-
Like, that's why I'm like, I don't think they're looking at the projector that often.
No, we're not.
Your co-counsel wants to look.
Ah, yes, that's important in a
Here, do
closing.
you want to turn?
I can't turn that thing.
I'm with you. I need a pacer.
Yeah, I just want to be able to.
Yeah, I did a closing what, last week.
I don't think it just.
I had to have a projector.
It does.
Wait, are you able to?
Give my money.
Jerry did not want to work pain and suffering.
Is it?
Is that thing off still? Okay.
We tried our best, and that's what really matters. Isn't it?
Well, now we don't see. You know what, old fashioned, just give me the exhibits to hand on.
I think that's a great idea.
Okay. I love it. Level.
Getting judged on this too.
This is how it works in the real world.
Yeah.
100%. Happened to me.
Got an audible.
I will attest to that.
Both sides ready?
Yes, Your Honor.
All right, let's proceed with closing, starting with the plan.
May it please the court.
The floor is yours.
We still had time to land. Imagine Mrs. Fortenberry, conversation you heard about through her deposition. She gets a call by someone she doesn't know, has no reason to know, doesn't recognize. In the middle of the night, she's woken up. She's woken up to be told that her husband has been through an accident. Her husband's been through a crash. She hears that he won't be coming home. He won't be coming home because he has just passed away. But she doesn't know the full story yet. Mrs. Madeline Fortenberry learns, as she told you, that she hears that Mr. Fortenberry, her husband, didn't just close his eyes and leave us. No. He went through a cracked skull, spinal injuries, a torn lung, a ruptured spleen, a broken leg, and a broken arm. And he sat there in a metal casket as his life was fading away for 5 to 7 minutes. And he suffered for every single one of those minutes. This is what he was trapped in. There was no one with him at that time. There was no one he could contact. There was no hand for him to hold. He was just in the middle of a ranch with no lights. Couldn't see anything. Now, as he's in there, and as he's trapped, he has one thing next to him. He has a picture, and that's what's recovered. And that picture is a picture of his wife. That's the only thing he had. This picture, as you'll learn, was the very last picture Mrs. Madeline Fortenberry will ever be able to take with her husband. She doesn't get any second chances. She won't get any others. This is what she has to remember him by. And all of this was avoidable. And you heard that. All of this was avoidable if the defendant just bothered to pick up the phone. You heard from Mrs. Madeline Thornberry that at becoming a widow at 22 years old, her life changes and her life changes forever. She can't sleep the same. She can't walk the same. She can't talk the same. She can't do the things that she wants to. It's almost as if she was trapped too. Not in that metal coffin, but in her own head. Because of what the defendant did. Now he got here before you today. He tried to wiggle around some questions and some answers, and we need to talk about those things. Because the fact is, none of this needed to happen. None of this needed to happen if the defendant just bothered to live by the promises that he agreed to. You heard it from every single witness in this case. When you take money from the federal government, that's not a donation, it's not a scholarship, right? It's not free money. You agreed to certain things, and she just agreed to two. The lights stopped working, you fix them, or you tell someone. And the reason why that matters, Mr. Bell told you. Mr. Bell told you today that if I knew those lights were not working, I would have never sent Mr. Fortenberry out there. That's why that matters. And that's why they start telling you, oh, you know what? I don't know exactly if the lights weren't working. But then consider what their expert said. Their expert said she agrees that the lights were not working the day Mr. Fortenberry died. She agreed, and she told you she had to admit that no one came out to the runway to fix those lights within the 10 days that Mr. Fortenberry knew something was wrong with it. Meaning that the lights were not working the day of Mr. Fortenberry's crash, and they were not working for a whole 10 days. The reason why the defendant didn't know what was wrong with it is because he never bothered to ask. He never bothered to live up to his end of the bargain. And because of that, Mr. Fortenberry paid the price. Mrs. Fortenberry paid the price. Now, me and Mr. Williams represent Mrs. Madeline Fortenberry in this case, and as plaintiffs, we had the burden. We had the burden to prove to you by preponderance of the evidence that T-Bone Thompson was negligent. Now that's all legal jargon, and we can just go through them line by line and talk about what this just even means. Now, the judge is going to give you the definition of negligence and the definition of ordinary care, but all that it really says for ordinary care is the same degree of care that would be used by a person of ordinary prudence under the same or similar circumstances. What would that person do in those same shoes? Would that person pick up the phone and call the FAA? Or would they just say, hey, you know what? I gave it to my ranch manager. That's who's supposed to take care of everything. Never bothered to ask the ranch manager what happened. Never bothered to find out what was wrong with the lights. Now, we read the regulations. Mr. Williamson had to get up here and read the stipulation, the agreement between everyone here today. Put it in front of T-Bone Thompson, and she had to agree. It was the owner that had to call the FAA. It was the owner that had to notify the FAA that the lights were not working. She says, I told my ranch manager. I hire people for them to do that kind of stuff. It's not on me, it's on them. Started pointing the fingers. By question number 3. So for this, we have question number 1. We have Mr. Thomas Thompson on question number 1 and Mr. Zeke Fortenberry. Now, we all agree, everyone here is in agreement that Mr. Fortenberry did the math wrong. Mr. Fortenberry ran out of fuel. We do not dispute that, and because of that, we agree. A person in his shoes should have done the math right. We agree with that, and for that, we ask you to put yes for Mr. Fortenberry and for Mr. Thompson. I just want us to consider two things when we move on to question 2. Because for question number 2, we're apportioning fault. Now, let's go over what we heard in the case today. We heard that a pilot in those similar circumstances has to do the calculations and has to do the field. You have to do it just like a person would in the same circumstances. Now, we know he did them wrong, and the defendant hired an expert to come and do them right. The expert made some miscalculations. Has she agreed to you? And this is years after the incident. She's had years to perfect her math. She's had years to know how to do this right. Exhibit A, she made a miscalculation. So an ordinary person in Mr. Fortenberry's shoes, a pilot that doesn't have 2 years to come up to these numbers, someone's bound to make a mistake. That's what these runway lights are for. They're for emergencies. But that wasn't the only mistake that their expert made. Their expert made another. Came out to 27. She wanted to take the average of 25 and 30, and she said 27 is in the middle. This is the second mistake she made. She did it on the stand. She had to admit it to you too. So miscalculations happen, and we're not running away from this. We just want you to consider Mr. Fortenberry and compare him to someone ordinary, someone prudent in his circumstances. And that person may make mistakes. But the only reason why we have pilots in the first place is because mistakes happen, miscalculations happen. That's the only reason you need them, right? That's the only reason the federal government pays for these types of things. Now, because of this, what we're asking you to do is put 30% negligence on the part of Mr. Fortenberry. We think that's fair. We think that's reasonable. We want you to put 70% negligence for the part of Thomas Thompson, T-Bone Thompson. He just didn't do what he was supposed to do. And because of that, Mr. Fortenberry was the one that had to pay the price. Unfortunately, he didn't have a backup. That's what the plaintiff said. The plaintiff got up here in opening statements and said Mr. Fortenberry had no backup when he ran out of fuel. We agree with them. We agree with them because the lights didn't work. He tapped the microphone as many times as he could, and they did not come up. For 5 minutes, he was circling that runway, and he tried to land. He tried to see. He couldn't. But he still had time to land. He still had time to see. He just couldn't because of what the defendant did or did not do. When you look at the picture of the crash, you see that he's lodged in a forest. You don't end up in a forest because you're out of fuel. You end up in a forest because after 5 minutes, you could never find the runway. A runway that was quite wide. A runway that is quite long. You would be able to see this if it had any lights from anywhere. He ends up somewhere around there in the forest. He had to gamble on where to land. And that's all because of that. It's all because of what he did not want to do. Too busy making mistakes. Now, from the beginning of this trial, what has happened is the defendant got up here and tried to point fingers. The judge had to stop them in opening statements and tell them, hey, stop pointing the fingers at the FAA. No one is blaming the FAA in their opening statements. First thing out of the door, the judge had to instruct you, hey, disregard that. Don't think about that. From minute one, they tried to throw spaghetti on the wall and try to see what sticks. But this case is more than just what the defendant did, it's what it caused. Because on question number 3, you are going to be asked a very strange question. And that question is, you're going to have to put a price on the pain and suffering that Mr. Fortenberry went through. And this pain and suffering, and I hope this is a question that you've seen for the first time and the last time. But this pain and suffering includes everything that Mr. Fortenberry went through. The 5 minutes that he had to circle around that runway, not knowing where he's going to land, terrifying. As Mr. Bell told you, his voice is crackling, he's cursing. He doesn't know what to do. He is terrified. It includes those 5 minutes. It includes the 5 to 7 minutes that he has to sit there in agony, suffering. All we ask for the pain and suffering that Mr. Fortenberry went through during that time is $20 million. It's because of what they did. He had to sit there in a metal casket, waiting for the last moments of his life to finally end. Maybe even hoping it. For the funeral expenses, this is going to be an easier task, right? Because we're all in agreement. I read out the stipulation. All parties agreed that the funeral costs in this case were $37,500. And that's what you're going to put down here. Now, the next question talks about the loss of companionship in society that Mrs. Madeline Fortenberry lost in the past. You've heard that it's been 4 years since this accident has happened. That's 4 birthdays, 4 Christmases, 4 New Year's, 4 Thanksgivings. But that's not all that is, right? Someone you love is much more than those holidays. You see them every day. You're excited to see them. You're happy to see them. You have your inside jokes with them. You take coffee to them when they're a little bit tired. You ask them how their day is because you care, because they matter to you, because of what that means to you on a daily basis. And when Mrs. Madeline Fortenberry got that call, she knew that came to an end. She knew that came to an end, and then she learned that Mr. Fortenberry had time to land. What she realized at that moment is that she had no more time with him. She couldn't take any more pictures with him. She can't look over on her side of the bed, over across the bed to see him there. Has to return to a cold bed at night and wake up in a cold. The moment she passes by the closet, smelling what his clothes smell like, going to games where he would go with her, hearing about Aggie football games that he loved, hearing about the things he liked, just bring up that phone call every single time. And that companionship is worth something, right? Now, putting a dollar figure on that is extremely difficult. But we're talking about a 35-year-old man losing his life. And a 22-year-old widow at the time, now 26. During the prime years of her life, she lost the love of her life because of that. And all we're asking for is $5 million for the loss of companionship she's lost in these 5 years. But for the future, it's much more than that, right? Because they wanted to have kids. And having a kid with someone is like having a little tiny bit, a little tiny piece of that person with you. You get to raise them, you get to care for them. You get to take them to football games, you get to take them to basketball games. You get to slap their hands when they do something wrong, and you get to praise them when they do something right. You have a right to be proud of your kids. You have a right to be happy for them. You have a right to have kids with the people you love. And that's what they stole from you. They stole that from Mr. Fortenberry, and they surely stole that from Mrs. Madeline Fortenberry. Under this, we're asking for $15 million. We think it's fair. We think it's reasonable. And under the circumstances, given that she will never get to see him again, we think it's the only thing that makes sense. Now, We're talking about the mental anguish Mrs. Fortenberry has gone through in the past. What we've heard is that she got diagnosed with depression because she couldn't do the things she regularly did. She couldn't move the same, talk the same. She was made different. She had to see the therapist continuously because she had lost a big part of her life. That phone call that she got in the middle of the night to be broken up, to know that her life has changed forever, that stays with her. And she will be reminded of that every single day of her life. If she hears the name Zeke, how is she going to feel? What is the first memory that comes to her mind? If she gets a call from the hospital for them to talk about one of her appointments, what happens when someone wears a similar type of shirt? That's the mental anguish you're talking about. That's the mental anguish you're thinking about when you're putting a monetary figure on this. But we think it's only fair for you to award $3 million under this for everything she suffered in the past. And that phone call, it has changed her for the rest of her life. Now, for the future and reasonable probability what she will suffer in the future, you heard that she's been going to therapy less, but I don't think that actually means she's going to hurt less. I think that just means she's becoming more resilient to this pain. And she's going to remember this for the rest of her life. And she is trying to do her best to move along. To be reasonable and to be fair, we think the only number that makes sense for this is $1.5 million. For everything she'll have to go through in the future. Because the runway didn't look like this, Mr. Fortenberry got trapped in this. You know he still had time to learn. We ask you to hold him liable for it. Thank you.
Your Honor, before we begin, may I read the track the law?
Your Honor, may I reserve 2 minutes rebuttal?
This is what real lawyers feel there. You're doing great.
You're getting the real experience.
Yeah, so much for the court reporter.
Details, details.
Constructive court reporter.
Let's start out by thanking you all, because this is a tragedy. This is difficult. Nothing about this is easy at all. We're having to litigate the death of a man who should still be here. I'll agree with plaintiff on one thing. There was still time to land. Mr. Fortenberry had 4 hours to land, to check his fuel. An instrument-rated pilot didn't check his instruments. Facts of this are difficult. They're emotionally taxing. I get it. We're human. I have a job to do. That job is to ensure a just verdict. A just verdict has four things. It requires you, the jury, to follow the facts. It requires you to follow the law. It requires you to follow the judge's instructions. And it requires you to apply all of them to the questions in front of you. Here are the facts. The facts are is that Zeke Fortenberry was an experienced pilot, an instrument-rated pilot. Zeke Fortenberry got into a single-engine plane that he did not own. That plane was a Piper Cygnet. That Piper Cygnet was 57 years old. Mr. Fortenberry did not check the weather from Kansas City where he was leaving. He only checked the Dallas TV weather. That Dallas TV weather did not indicate the winds that he would be flying to. It indicated the winds that we feel on our faces when we walk outside. You heard from Alex Bell, the air traffic control officer. Mr. Fortenberry radioed in when he was out of fuel. Not 5 miles before, not 10, not 20, not 100. A glance to the left or the right was all it took for an instrument pilot to use his instruments. He did not use them. We heard from their own expert, Sam Williams, that yes, his fate was sealed. And that Mr. Fortenberry, according to the NTSB, relied on surface winds from the local Dallas TV station. Winds on the ground, winds that a plane would feel when taking off and landing. Not what NOAA showed. Not the winds in the air. Not the winds his plane spins the vast majority time through. You heard from Thomas Thompson. Thomas Thompson's a business owner, a 70-year-old man, a staple in his community. He creates jobs. He creates an experience people can bond over. He creates community because of what he does for a living. Mr. Thompson had ample people on that runway managing it. Mr. Thompson did what he was supposed to do. He behaved reasonably under the circumstances. Opposing counsel would state over and over again, mistakes happen. Mistakes happen. Miscalculations happen. Maybe there was a mistake with the runway lights not coming on, but are we seriously going to hold Thomas Thompson to a higher standard than an instrument-rated pilot, an experienced pilot, not checking his instruments, not checking his fuel, not checking the weather, not checking what he's flying into in terms of the wind? You heard from Kim Bates, our expert witness. Kim Bates did the math. Mr. Fortenberry, in perfect conditions, may have had a chance to make it to his destination. That's in perfect conditions. This is what Mr. Fortenberry dealt with that night. He dealt with strong winds, and he wasn't even aware of them. He had no clue about the weather he was flying into. He had no clue that what he was going to be facing that night. Yet we're somehow blaming all of this on Thomas Thompson. Thomas Thompson can't control the weather. Thomas Thompson can't control an experienced instrument-rated pilot not utilizing the tools that are at his tool set. Thomas Thompson can't control an experienced pilot not looking left or right for 4 hours, for 430 miles. Ladies and gentlemen, the fact is that Mr. Thompson being responsible for all this is nothing shy of being absurd. Kim Bates also testified to the comprehensiveness of NOAA, to what NOAA can give pilots, showing pilots that at certain altitudes, this is what pilots will be facing. It showed what pilots would be facing in Kansas City, where Mr. Fortenberry was taken off from. He didn't check. It showed the altitude winds for Dallas, Texas. He didn't check. He didn't check at all. But we're summing this up to miscalculations. This was a blatant disregard. Experience? Nothing showed experience that night from Mr. Fortenberry. Those are the facts. The facts are that Mr. Thompson can't control what a pilot does when fueling their plane. It's a pilot's responsibility to fuel their plane. It's a pilot's responsibility to make sure they have enough fuel in their plane. It's a pilot's responsibility to check the instruments inside their plane. Mr. Thompson has no control over that. What caused the engine to fail? A lack of fuel. Mr. Thompson controlled the fuel in the plane? Not at all. Not one bit. Those were the facts. Oh, and I apologize. There's even more facts. There's more facts that people have landed on this airstrip in the pitch black of night. Isn't that something? People in the past have been able to execute this, landing. It's now Thomas Thompson's fault that this pilot, who completely disregarded the basic knowledge that a pilot should know before getting into a single engine 57-year-old plane, should do. We're holding Mr. Thompson to a standard much higher than that of Mr. Fortenberry. Mr. Fortenberry is held at the standard of a reasonable and prudent pilot in Mr. Fortenberry's circumstances. Mr. Thompson's held to a reasonable, prudent person in his circumstances. I ask you, who is more at fault? The facts were what I just stated. Here's the law. We have the burden of proof of showing Mr. Fortenberry's contributory negligence was the proximate cause of his injuries. Negligence means a failure to use ordinary care. Ordinary care means a degree of care that would be used by a person of ordinary prudence under the same or similar circumstances. Negligence means that the failure to use ordinary care, and by failing to do so, a person of ordinary prudence would not have done so under similar circumstances, or doing so, a person of ordinary prudence would not have done under the same or similar circumstances. What reasonable pilot doesn't check their fuel gauges for 4 hours? What reasonable pilot doesn't check the air that they're flying into? What reasonable pilot flies for 4 hours and realizes after 430 miles of flight, I'm out of gas? What reasonable pilot? None. We have to prove Mr. Fortenberry's negligence by preponderance of the evidence. By a preponderance of the evidence simply means more likely than not. So we have to prove Mr. Fortenberry was more likely than not negligent, but we also need to prove that more likely than not, Mr. Fortenberry's negligence was a proximate cause of his accident. A proximate cause means a cause that was a substantial factor in bringing about an occurrence, and without which cause such occurrence would not have occurred. In order to be a proximate cause, the act or omission complained of must be such that a person or company using ordinary care would have foreseen that the occurrence or some similar occurrence might reasonably result therefrom. There may be more than one proximate cause of an occurrence. Is it foreseeable for Thomas Thompson, a 70-year-old barbecue restaurant owner, is it foreseeable for him to go, hey, I think a pilot is going to disregard the weather in the air. He's going to disregard the instruments of which he is instrument rated in his own plane. He's going to completely miscalculate, and he's going to make an attempt to land on my runway strip that was not often used in a remote, unpopulated area. Or is it more foreseeable that an instrument-rated, well-seasoned pilot who does not bother to check his fuel while he's in the air, who does not bother to look at the air that he is flying into, will run out of fuel and crash 50 miles short of his destination? Again, I'm telling you the absurdity that is holding Mr. Thompson to a much higher standard than that of Zeke Fortenberry is unforgivable. There's nothing just about that. Those are the facts and those are the law. I'm sorry, those were the facts and that was the law. Now is the third part of a just verdict. Following the judge's instructions. Do not let bias, prejudice, or sympathy play any part in your decision. I'm not asking you to go back there and have a complete lack of sympathy for Miss Fortenberry. We all feel for Mrs. Fortenberry. This is tragic. I'm not asking you to betray what makes us essentially human. I'm not doing that. But heavy hearts do not change heavy facts. They never have. They never will. We have to separate the sadness that is this young man's life passing with understanding that he was the cause of his own passing and that blaming another man for it is not just. This takes us to our first question. Your fourth requirement is applying the facts, the law, and the judge's instruction to the questions in front of you. The first question is, did the negligence, if any of those named below, approximately cause the occurrence in question? For Thomas Thompson, but yes, the lights didn't come on. We understand that. For Zeke Fortenberry, you must also put yes. The next question is asking you to apply percentages up to who's more culpable for their negligence approximately causing Mr. Fortenberry's accident. For Thomas Thompson, who could not control the weather, who could not control Mr. Fortenberry checking his own gas, who could not control Mr. Fortenberry fueling his own gas, who could not control Mr. Fortenberry just looking at what the winds were going to be in the sky. But for the lights not coming on, put 30% next to Thomas Thompson. And for Zeke Fortenberry, who was pilot in command, who was an experienced, well-seasoned pilot, who got in that plane, who flew 430 miles straight, who didn't bother to check, place 70%. He was the primary cause of this accident. The plane does not fall out of the sky if he just checks. Question number 3 applies if you decide to find Thomas Thompson monetarily liable for Mr. Fortenberry's death and injuries, which is your right. You're asked several blocks of questions based on the degree of injury Mr. Fortenberry suffered. For pain and suffering, Mr. Fortenberry was on the ground for 5 to 7 minutes. Take his funeral expenses of $37,500 and multiply them by 5. To make it easy, write $150,000. We agree on the funeral expenses. In section B, $37,500. For a loss of companionship and society sustained in the past by Madeline Fortenberry, they were married for 3 years. I'm sorry, I apologize. This accident happened 4 years ago. For each year, take Mr. Fortenberry's funeral expenses and multiply it. Multiply 37.5 by 4. Let's make it easy, $120,000. Loss of companionship in society and reasonable probability that Madeline Fortenberry will sustain in the future. They were married for 3 years. Take Mr. Fortenberry's funeral expenses and multiply them by 3 to make it easy. Let's make it $100,000. For the mental anguish sustained in the past by Madeline Fortenberry, the accident occurred 4 years ago. She had to bear with this for 4 years. Take the funeral expenses again and multiply them by 4, round it $120,000. For mental anguish and reasonable probability that Madeline Fortenberry will sustain in the future. Take Mr. Fortenberry, she's healing, she's getting better. She's seeing her psychiatrist less. She's hanging out with friends now. She said it herself in her deposition. Her friends are helping her get through it. Take the funeral expenses and reduce them in half. Let's make it easy, $20,000. A just verdict requires 4 things. And if you do these 4 things, you're going to do a good thing today. You're going to get to go home and say, I did the right thing. I did the just thing. Because my client, Thomas Thompson, he can't control the actions of Zeke Fortenberry. And a just verdict requires you to take notice of that. Find Zeke Fortenberry negligent for his own actions and the cause of his own death. Thank you.
They got up here and said it's a blatant disregard. You know what a blatant disregard is? When they ripped this picture off the stand while it was published, while we were talking about it. While we were talking about a man that has died. They ripped this picture down. They didn't want you to see it. That's what a blatant disregard is. A blatant disregard is when they reduced Mr. Fortenberry to his funeral expenses. As if that's all he is. Their argument was, people have landed on this runway when the lights didn't work in the past. No one died on this runway in the past. So it's Mr. Fortenberry's fault he couldn't see. Now that's absurd. T-Bone Thompson had 10 days to fix his mistake. Mr. Fortenberry had 10 minutes.
Is that my trap?
Good job, Council.
Thank you. Thank you for taking your time.
Of course, I only do this for Judge Williams.
I'm the only one that does my trial
It's like that. But you will only be doing this for her.
I appreciate it.
You want us to walk out for 10 minutes while y'all?
Yeah, I gotta sit outside, it's so bad.
No, just criticize me in my face.
Yeah, I want to hear it. I want to hear it. It's on this.
Council, why don't you take this back? You do this again. Whoever did this to me.
Yeah, I hear it. As long as we get here, but
No, we go.
5:50.
We don't need it.
5:45.
Do you get these back? Because
You have garbage all over.
I do too.
I was very confused about the tables, so.